Someone make it make sense.
Probably a couple.
Trials are public, okay? Our courtrooms are public. I think you know that, I know that, we all know that. And during the course of a case, the litigation, the going back and forth, each side filing motions, trying to get the other side to do something, trying to exclude evidence, whatever the motion is, these things are all part of the court docket. And when you have high-profile cases or regular cases, most states around the nation do a really good job these days of putting this stuff online. Idaho is one of those states that is really good at this. They have a high-profile case. They're going to put all of the court filings and everything online. I want you to take a look at that docket right now because you're going to notice something really interesting about it as we watch it. Okay, look really closely. Order to seal, 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 order to seal. They're sealing everything. Not everything, but a lot of things. Like all of these orders to seal evidence and seal motions and seal documents. They've even closed the courtroom doors to have sealed hearings. Now, CourtTV, we cover trials all around the country, primarily murder trials. Everything is serious. Everything is high profile. Florida, Massachusetts, New Jersey, Arizona, California, all over the country, Ohio, South Carolina, Florida, and Florida again. So what is happening here? We saw all of these things are sealed, including some of the hearings in a public case in a public trial, which brings me to the first question in my investigation tonight. Why is everything sealed? Is this normal in Idaho? Is this the way justice is done in Idaho? Is it not as transparent as other states around the nation? Do the people of Idaho and the public not have access to things that are happening inside of their courtrooms? It's unusual for me.
Okay, so welcome, guys. Let me share this. So welcome, everybody. Need some Z says, I'm not sure what you mean by 2023. All those docs were from the judge of the state. Oh, are you saying that you thought he was implying that those documents were from the defense? Because I don't think that's what he's implying at all. I actually think that, in the entire clip, the entire episode from a couple of days ago, I feel like he's implying that, it's clear that all those motions and orders to seal are, they're coming from the judge or the state. So I'm not sure if I'm quite understanding your comment, but yes. So, okay. So that's what I wanted to start with because I thought that was a good way to get into this. So all these documents we've been waiting for, guys, we had a bunch and then some, and we also had a surprise hearing. We're going to watch that too. So, all right. So first, here we go. First on the docket here. So order denying. So remember when we covered last night the interested parties, right? That had a motion to be heard. And I was thinking, I bet it's the media, right? Okay. Order denying petitioner's motion to be heard prior to January 21st, 2025 hearing. So the interested party thing, that was because they wanted to gain access to the hearing from yesterday. Okay. The following items. So motion to be heard as interested parties, memorandum in support of motion to be heard as interested parties, and a proposed order granting motion to be heard as interested parties were received by the court immediately prior to the scheduled hearing with the parties at 10 a.m. on Tuesday, January 21st, 2025. So as soon as I read this, I was like, I already see where this is going. Untimely, right? These documents shall be docketed as exhibits to this order. Given the untimely filing, there it is, the court was unable to accommodate the request for the hearing by the petitioning media interests. Today's hearing with the parties was designed to establish a schedule for the hearings on the January 23rd and 24th upcoming hearings, which is really funny. That's what I always call it, right? And it was closed to the public because the very purpose of the hearing was to discuss what specific information currently sealed must be protected during the upcoming hearings on the 23rd and 24th, and how best to do so. To formulate a plan to allow as much public access as possible at the upcoming hearings, the court needed to have today's hearing closed to have a candid discussion with the parties about the information that previously had been sealed or subject to non-dissemination orders. As such, the court, acting within its discretion, proceeded with the closed hearing. Shout out to Kane as well. Happy to see you as well, my friend. And okay, so next up, we've got these. Well, we've got the everything related to the IGG, right? And so let's just take a look here. So, I'm going to make sure I didn't miss anything. So we did. Yeah, so we're going to cover these: the reply to the state's objection. Oh, I knew I was missing the state's objection. Aha, because they're out of order. Let me make sure I cut that. So we're going to cover the state's objection, and then we have the reply to the state's objection. Then we have the order regarding the presentation of IGG evidence, and then the order finally denying the motion to unseal. So we're going to go through all of this. But because we're starting with the interested parties, right? The next thing we're going to do is we're going to watch the surprise pop-up hearing from today with the media. Okay. So, okay. So let me pull that up. Okay. And here we go.
All right, we are on the record in State versus Bryan Kohberger, CR 0124 31665. The state is represented by Mr. Thompson, Mr. Nye, and Ms. Jennings. The defense is represented by Ms. Taylor and Ms. Massoth. The defendant has been excused from appearing. The defendant himself has been excused from appearing today. With us also are petitioners, counsel representing petitioners, Ms. Olsen and Mr. Pedersen. Today's hearing was set to address the interested parties' petition to be heard as interested parties related to the court's closure of a portion of the hearing set for Thursday and Friday. So with that, I will let, whether it's, I'm not sure if Ms. Olsen or Mr. Peterson is addressing the court today, but whomever is may address the court.
Thank you, Your Honor. Will be Ms. Olsen on behalf of the interested parties who are various media organizations and professional journalist organizations with a history of covering the proceedings in this case. And the interested parties thank the court for this opportunity to address this issue regarding.
I want to say, Denise, I feel like you might be new here because I don't know that we have an Idaho squirrel yet that lives in Idaho. So welcome and thank you so much for being here. Please let us know where in Idaho you're at. And that is awesome. So happy to have the locals. Love it. Awesome.
Access to the hearings that are scheduled to start tomorrow at 9 a.m. Your Honor, as the court knows, the United States Supreme Court has long acknowledged that the First Amendment protects the rights of the public and the press to attend criminal proceedings. And while few cases in Idaho have dealt directly with public access to pretrial proceedings, and in particular suppression hearings, at the federal level, both the United States Supreme Court in Waller versus Georgia and the Ninth Circuit in Associated Press versus U.S. District Court for the Central District of California and in United States versus Bryan have addressed the issue. Waller did so in the Sixth Amendment.
So you're okay. So you're from somewhere. So you're flying to Boise. So first of all, remind me where you're at, and then also you're attending these hearings. I take it that is incredible. You flew. Wow. So you're in, okay. No wonder, right? Because I thought I recognized the name, but I was like, I'd remember if somebody was from Idaho. That makes sense. Now it's all making sense that you are in Idaho because you flew there. Okay. Got it. From Cali. Okay. Gotcha. Right. Wow. Okay. Amazing. So you're going to be going to the hearings. I take it. Holy mackerel. And we're going to be covering those. I was kind of debating whether or not I wanted to stream those live as they were happening, but I think I'm going to do these hearings in the evenings after the fact, just because I know that there's going to be a lot of people streaming it during the day. And it also seems like it's going to be a little bit chaotic potentially with the cameras or the live feed coming in and out and whatever. But I'll be watching it, but I'm going to be covering those. And then I know most of you guys we'll be watching the hearings more than once anyway. So that's sort of the plan. Denise says, I'm a whirly squirrel trying to get in tomorrow. Wow. Well, best of luck. Please, if you want to join the Discord, then you can keep us updated with what's going on. If you feel so inclined, and let us know as a boots on the ground, as they say. That would be awesome if you want to do that. We would love to get those updates from somebody who's there. So yeah, I'm in North Carolina. I wish I could be there. So
Context. Brooklier found that the First Amendment right of access extends to suppression hearings. In an Associated Press, the Ninth Circuit extended the logic in Brooklier to pretrial filings, writing in the very first part of its opinion.
And the link for the Discord is in the chat too. Awesome. That's awesome. And we love whirly squirrels too. Just had to say that as well.
No reason to distinguish between pretrial proceedings and the documents filed in regard to them. Notably, both Associated Press and Brooklier involved high publicity, highly public defendants and charges. Associated Press involved federal narcotics charges against, among others, John DeLorean, and the Brooklier case involved a RICO prosecution against members of the criminal enterprise La Cosa Nostra. Waller, in particular, in its decision, sets out the benefits that the U.S. Supreme Court has seen in its various decisions that arise from public proceedings in criminal cases. It notes that in Gannett, a case in which the United States Supreme Court looked at but did not decide the issue of press access to suppression hearings, that the requirement of a public trial is for the benefit of the accused, that the public may see he is fairly dealt with and not unjustly condemned, and that the presence of interested spectators may keep his triers keenly alive to a sense of their responsibility and the importance of their functions. And in turn quoted other cases. In addition to ensuring that the judge and the prosecutor carry out their duties responsibly.
And that's true. Yeah, that's right. So he did say that it was going to be close to the public. That had already happened. But that's what this is like. There's a lot of moving parts here, right? So this hearing right now that happened just today, spontaneously, right, is for this exact purpose, right? And I haven't watched this yet. I don't know what will happen, if anything. He had already said it will be closed. And I had commented on this last night that, it's close to the public is in terms of attending, right? But the thing that I commented on last night is like, it bothers me because like they've had this, every hearing this comes up, right? Where it's like, there could be things. And what they've done is they've just grouped things together, right? So that they can have it closed and then they can open it up, right? And to just go ahead and say, we're going to close it to the public entirely, I don't know. It's just, there's ways to handle it. And they've done this before. So I don't know. We'll see if they get anywhere with this hearing.
Witnesses to come forward and discourages perjury. Your Honor, prior to closing a criminal proceeding, the court must afford those excluded from the proceeding reasonable opportunity.
In other words, he could change his mind on that, right? He could put out another order. So we'll see.
Objections. We appreciate the court providing us that opportunity here. And the court must also comply with the requirement set out in Press Enterprise 2 before it can close those proceedings.
Good.
A criminal proceeding can only be closed if the court makes specific findings on the record as required by that case. And those specific findings need to be sufficient in writings, insufficient so that a party excluded can challenge them. The Ninth Circuit has explained that a court cannot be closed in criminal proceedings unless such closure serves a public interest. There's a substantial probability that in the absence of closure, this compelling interest would be harmed, and that there are no alternatives to closure that would adequately protect the compelling interest. And that's in Oregonian at 920 F. 2nd at 1466, quoting from the
That's
press
the thing, is
enterprise.
there
Digest.
are alternatives, right?
Here, Your Honor, the interest parties are not arguing for a blanket order opening the court. We are arguing for the court to adhere to this long-established process of determining how and under what circumstances
Yeah.
a court could be closed for a hearing. For many of the media outlets we represent, even in national security, child sex assault, and organized crime cases that they
Yeah.
cover,
Yeah.
the process that we are seeking has been carefully followed. The public and the media have a right to
Good
appeal
point.
unwarranted closures of a courtroom, but they're unable to determine whether the court is being closed appropriately because the court so far has not made public the most basic information regarding the reasons for its closure.
Mm.
The defendant in this case, in both its January 13th and January 21st filings, seeks an open hearing and asserts that an open hearing is of utmost importance to him. Therefore, any concerns about the closure being required to ensure the defendant's right to a fair trial are moot. And as Mr. Kohberger pointed out in his motion to hold an open hearing, the Supreme Court in Waller held that when the defendant objects to the closure of a suppression hearing, the hearing must be open
Ooh,
unless the party seeking to close the hearing advances an overriding interest that is likely to be prejudiced.
let's listen. That's crucial. Let's remember, because of course it's all about the defendant's rights. Let's listen to that again.
And as Mr. Kohberger pointed out in his motion to hold an open hearing, the Supreme Court in Waller held that when the defendant objects to the closure of a suppression hearing, the hearing must be open unless the party seeking to close the hearing advances an overriding interest that is likely to be prejudiced.
There you go. So great point there. So I just wanted to say shout out to Top Cat. Now here's the thing, Top Cat, I love this so much. So Top Cat is joining us from Australia, and has already watched this hearing. Now what's awesome is, as of what, correct me if I'm wrong, Top Cat, but as of like a few days ago, Top Cat was like either brand new or relatively new to this case, and has been getting caught up to speed at rapid fire pace, right? To the extent of which has already she's already watched this here. I love that. That's awesome. I'm really glad that you hopefully you're enjoying following this case and everything. And I love that. So yeah, Hippler. Y'all know how I feel about Judge, right? And Judge Hippler, who I've called Judge Stickler and Judge Grinchler. I think that he, my yeah, that first hearing where he didn't want to be there is like, yeah. So, yeah, that sucks. I mean, one would only hope that he's actually listening. And even if his demeanor is negative and pessimistic and all that, right? One would only hope that he actually considers it and, overnight, maybe he'll sleep on it and be like, oh yeah, here's the right thing to do. So
the burden is on the party seeking closure. That's from Oregonian 920 F. 2nd at 1467 and Brooklear 685 F. 2nd at 1167. As we understand it, Your Honor, the interest being advanced by the state is concern for information being provided to the potential jury pool and possible inadmissible evidence being discussed in open court. But that is inherent, Your Honor, in any motion to suppress hearing. The whole basis of the hearing is to see whether the evidence should be excluded or admitted at trial. Concern about the public maybe learning about this evidence, and even if it ends up being inadmissible, is therefore not an overriding interest. And absent that some evidence that this discussion that would occur in the hearing would prejudice the jury pool or provide information that would be difficult to seat a jury, I think that is also not sufficient evidence for this court to find that it's a compelling interest and warrant closure of the hearing over both Mr. Kohberger's objection and then the right of public access. It also appears from Mr. Kohberger's filing yesterday that the state asserted that Mr. Kohberger's acquiescence to the non-dissemination order is somehow a basis for them to argue that Mr. Kohberger cannot now object to this closure. Not certain if that was the argument the defense, that the state advanced, because we haven't seen their pleading. It's not on the cases of interest website. But as I understand the non-dissemination order, Your Honor, and its purpose, it's directed at comments or statements that are made outside of court proceedings and pleadings, and not at what can be said by the parties or their counsel in the courtroom. And the very purpose of the non-dissemination order, as I understand it, Your Honor, was to prohibit those sorts of extrajudicial comments by people who would be in the know, but that in court proceedings are precisely the kind of information that should be available to the public as the case moves forward. Your Honor, I would submit also that there is tremendous public interest, and it serves a tremendous public good for the public to know at the time that it's being considered the evidence, whether the evidence that the state seeks to introduce at trial was gathered in a method that is constitutional or meets evidentiary thresholds for admission.
I just want to say shout out to Denise. Denise made it to the Discord, and y'all can see she's just posted a picture of there being on of the Idaho Statesman. Awesome. I love this. So that's so cool. I love that you're going to be there and you're going to be able to keep us posted. That is awesome. Thank you so much.
A motion to suppress may be the critical stage of a criminal case. If essential evidence is suppressed, then the government will not be able to meet its burden of proof at trial. Indeed, Mr. Kohberger made that exact argument in his filing yesterday. The purpose of the IGG was to investigate a criminal case.
Here we
What
go.
is more, without IGG, this case would never have been brought against Mr. Kohberger.
Yep.
The public should know precisely what law enforcement and prosecutors did in gathering such evidence and why and how the defendant thinks that was illegal. The court in Waller, when it was talking about the aims and interests of a public trial, noted that those aims and interests are no less pressing in a hearing to suppress evidence. And then they pointed again to several of the individual opinions in Gannett, the case where many Supreme Court justices opined that if they were addressing the question, they would say there's a First Amendment right of access to suppression hearings, but they didn't reach that question.
Squirrel call for Heather.
In Gannett, the comments that many of those justices made was that in many cases, the suppression hearing was the only trial because the defendants thereafter pleaded guilty or the evidence was suppressed and no case went forward. And similar reasoning supported press access to preliminary hearings in one of the few Idaho cases to address access to pretrial hearings, and that was the Cowles case. In Cowles, the Idaho Supreme Court noted that the process in conducting preliminary hearings in Idaho is likewise sufficiently like a trial to generally justify public access. And they pointed to the Supreme Court opinion in Press Enterprise 2, where they state that because of its extensive scope, the preliminary hearing is often the final and most important step in the criminal proceeding. The preliminary hearing in many cases provides the sole occasion for the public observation of the criminal justice system. And that may be the case in a motion to suppress hearing, particularly if either that motion is granted and not sufficient evidence exists to go forward, or even it is denied and a plea deal follows the resolution of the motion to suppress. In a Franks hearing, Your Honor, the court is addressing the very critical issue of whether a law enforcement officer made deliberate or reckless false statements in an affidavit submitted to the court. And prior to holding such a hearing, a court is to determine that whether the defendant has made a sufficient threshold showing that an actual hearing is necessary. An actual Franks hearing,
talking about Franks, and we're going to get to more of that too with the court docs.
in my experience, Your Honor, is unusual. On issues as critical as these, whether evidence was gathered properly and whether law enforcement made deliberate or reckless false statements to a court in gathering evidence, there is significant public interest, and public access plays a significant positive role in the functioning of the particular process as the court outlined in the earlier cases I've identified. It's particularly true here, I think, Your Honor, with the Franks hearing, where there is that question regarding the truthfulness of the officer involved. In any criminal case, I would submit that it's of extreme public interest to know whether a law enforcement officer swearing that they have told the truth in a filing with a judge that will be used to gather evidence that can significantly impact the life, liberty of an accused, whether that law enforcement officer did in fact tell the truth, or whether the officer made deliberate or reckless false statements. I think it would be different, Your Honor, if it were a private citizen who made it.
And that's the standard for Franks, right? We've covered that extensively. That's the standard for Franks, right? That a law enforcement officer made a false statement either intentionally or knowingly, or with a reckless disregard for the truth, right? That's the standard.
A misstatement of facts, and there was a hearing about perhaps that person, the calculus might be a little bit different, but this is a person, a law enforcement officer who is cloaked with authority and has the ability to seek process, to get evidence, and ultimately lead to charges against an individual. Your Honor, the last thing that the court has to look at with respect to whether or not to close a hearing is whether there are alternatives to closure. And Your Honor, it is a little difficult in this situation for the interested parties to specify what that alternative to closure might be. But sort of looking at the documents that have been filed in this case and understanding that one of the initial concerns with the IGG evidence is the identity of perhaps family members of Mr. Kohberger.
Y'all know how I feel about that, right? It's I like quoting the state here, quote, hundreds of innocent relatives, right?
I would submit that there are two alternatives at least that might address that. One is that it's possible, of course, to show exhibits on a monitor in a hearing in court in a way that they're not displayed to people who might be watching online or in the courtroom, similar to what is done when there is a piece of evidence or an exhibit that is offered, but it's not yet admitted. We would also submit, Your Honor, that perhaps redactions or some sort of general identifier, person 1 or person 2, in the place of a particular name would be sufficient if indeed the concern is revealing the names of relatives of Mr. Kohberger. That's very similar to a process that is done in healthcare fraud cases when we're dealing with individual patients whose records may be at issue in a case, and not a medical malpractice case, but a healthcare fraud case where we're looking at the billings, and those individuals are often identified, for example, by a random number or by a Medicaid identifier number, not by their name. So their names are never revealed in the course of the proceedings.
That is a really good point. I know some of you guys have already watched this, but that's a really good point that that you can use a number, right, to identify people so that, you know, you've never disclosed their names. That is a really good point and a great suggestion. I mean, I think in my view, from everything we've covered, the whole thing about the family names, like, remember, right, for example, in the defense's motion, right, for the unsealing of the IGG briefs, one of the things that I've pointed out many times is that I thought was really important is how they say no names of any family members are even listed in the briefs, right? And that was like, yep, well, I feel like that's because there aren't any, but should, you know, to the extent that the state wants to argue that there's hundreds of, quote unquote, hundreds of innocent family members or whatever, hundreds of innocent relatives, this would be a solution to that argument.
And so, Your Honor, we would submit that alternatives to closure such as that would be available to the court if the concern is identifying those particular names of people who are extended relatives of Mr. Kohberger. Finally, Your Honor, openness and transparency are more important than ever in maintaining and restoring public confidence in our government institutions, in our courts, in law enforcement, in prosecutors' offices, and in institutions of the media. Open hearings, like an open suppression hearing, are necessary to let the public see how this critical part of our criminal justice process works. Thank you, Your Honor.
Thank you. Does either the state or the defense wish to add anything based on Ms. Olsen's argument that was not previously presented?
I would like to make a record on behalf of the defense.
So now we have Ms. Massoth.
Beyond what you did yesterday?
It would be consistent with what I did yesterday.
Okay, but I heard what you did yesterday.
Oh, for
So
fuck's sake.
do you have anything new to add?
You know, that's messed up, and here's why. Like, you know what? We didn't hear what she said yesterday, sir. Judge Stickler.
I don't have new information to add, Judge, other than having the ability to talk with the team about what your suggestion was and our concerns about arguing in open court. Would you like me to just address that?
I'm
I know,
not sure what you're referring to, so I apologize.
So we had discussed.
So I mean, I couldn't agree more. It doesn't make any sense. And that's why, like, you know, I've had that theme. My opening has been that since the get-go, with EDB saying, somebody make it make sense. But if you guys saw the thumbnail, like the squangwin in the thumbnail for this one is like, someone make it make sense, please. Because it makes no sense. Yeah, that's why.
That the evidentiary hearing portion of it for the IGG would be closed.
Correct.
But that we would argue the legal arguments in open court if we did not talk about the evidence that was brought out in the closed hearing. And after thinking about it overnight and talking about it today, we do not think that we can parse the argument that way. So it's still our position that all of this should be held publicly, openly in court. And that's our same position with the Franks.
Yeah, I mean, yeah, there's all kinds of high profile Casey Anthony. I mean, I'm still covering that gavel to gavel. I mean, all these high profile trials. And that's one of the things Vinny mentioned in that show from the other day too, about he actually says that same thing. He lists all these high profile cases. He's like, I've covered all these and, you know, I've never seen anything like this.
The Franks proffer, with the exception that there will be in the proffer, there will be a need to talk about specific names and in particular names of some lay witnesses in directing the court to the 1,000 pages that were submitted under seal in relation to the proffer.
All right. Well, with
So
respect to
that's the
with respect to the
information
names,
that I have.
I'm sorry. With respect to the concern with respect to using names, submit a list of names with initials tomorrow, and you can use the initials.
Okay, we can do that.
Anything from the state, Mr. Thompson?
Not me, Your Honor. Mr. Nye was actually speaking on behalf of the state yesterday. I'll defer to him.
Mr. Nye?
No, Your Honor, nothing beyond what was said yesterday. Thank you.
Well, I appreciate the presentation today. I will note this case is a little bit of an unusual posture in that there was previously a non-dissemination order issued in this case in which it was clear the tract of the court and at the time the parties was to avoid given the media scrutiny, the potential for impacting the jury pool that exists here with evidence that may ultimately not exist and evidence that may not ultimately be admissible. That order was challenged, I believe, by the press at the time, and the full hearing was held on that, and the judge issued an order on that. The closure of the proceedings thus far have been consistent with that prior ruling by the court for which the petitioning parties were given an opportunity to be heard previously. I don't think much has changed in terms of the need to protect the jury pool here, given the intense media scrutiny that has and continues to follow with this case. Part of the rationale presented to the court yesterday for opening it was in order for the defense to make their case to the public. It's exactly why it's not open. We will be challenged under the best of circumstances
What?
of obtaining a jury that
No
is not-
way. So I'm going to listen to this part again. It seems like he's so far his rationale. This is not, honestly, this is not what I expected because like, hold on. He's also like contradicting himself. Let me back this up again. And I'm going to break this down. Okay.
with that prior ruling by the court for which the petitioning parties were given an opportunity to be heard previously. I don't think much has changed in terms of the need to protect the jury pool here, given
I don't think much has changed in terms of the need to protect the jury pool here.
and the intense media scrutiny that has and continues to follow with this case.
So that to me, the way I interpreted that when he said it is that like, there's going to be coverage. There's going to be media scrutiny. There's not much else that can be done to protect the jury pool. Like, you know, it's going to be the way I interpret that. And again, more for like further is like, this is going to come down to how, you know, voir dire, right? When it comes to the jury selection process, because, you know, it is what it is, right? Like, in other words, it sounds to me almost like he's accepting the fact that there's going to be tons of media coverage and either people are going to have heard of the case or haven't heard of it. And if they've heard of it, have they formed an opinion, right?
Part of the rationale presented to the court yesterday for opening it was in order for the defense to make their case to the public. That's exactly why it's not open. We will be challenged under the best of circumstances of obtaining a jury that is not been overly exposed to this, and in particular exposed to evidence that ultimately may not come into this trial.
So now this is why I was surprised, because he's like, it's like, well, wait a second. So now you're saying that the reason you're wanting to have it closed is because you're worried about the public learning more information when you've already just previously said it's like, I don't, do you guys see how it seems like he's contradicting himself there? And again, the whole point of this, like, is so that the public can learn what happened in this case. That's the point. So his rationale here sounds to me like, at least at this juncture, that okay, right. The point of the open hearing is so the public can learn what happened. And he's saying, we don't want the public to learn what happened because we're worried about tainting the jury pool, essentially, right? But also he's saying, I accept that there's going to be tons of media scrutiny and lots of coverage in this case. And the first thing he said just a second ago was that like nothing's going to change as far as the exposure to this case in Ada County or whatever. So I don't know. Need some Z's? I'm not sure. Why do you keep saying is rude? I don't know what you're referencing there. Yeah, and I totally agree here, right? You know, Oh, or you're saying this is what's rude, I guess. All it does is continue that they're hiding things from the public that shouldn't be. Are you saying that's what's rude? Because yeah, I mean, I would agree. I don't know that I would say, I mean, rude. It's rude, and also it's a lot of other things, right? I mean, it's a problem. It's a problem. Right. Yeah. It's like using but that's why it's crazy, right? Using intense media coverage as an excuse, but yet previously saying that he's accepted it and it is what it is, and he doesn't think that it's going to affect, like he said, like the jury's not going to be affected. Like nothing, he said something to the effect of like, nothing that we do now is going to change the exposure that this particular jury pool has to this case. So why, like, I don't like this. Yeah. Okay.
I am, as I told the parties yesterday, particularly sensitive about closing things when we don't need to. And I think that there has been to date a over.
Okay, gotcha. Nismz says she was referring to not allowing Matt. Right. I agree. Yeah. Right. And again, like not, yeah, two things, right? So that was from earlier when he was like, you already said this yesterday. I agree. She needs to make a record. And also, like I pointed out too, you know, we didn't get to hear from yesterday too. So
Caution in asking that I seal things by stipulation that perhaps don't need to be sealed. And I've asked the parties to stop that, frankly, and to provide better rationales as to why I should seal what they're asking me to seal.
Welcome.
That said, with respect to in particular, the IGG issues, particularly where I don't exactly know what the evidence will be forthcoming, I am concerned about the potential.
So I'm going to back this up again because I think this is what, like, this is just the rationale here, right? So back to the part about the jury pool, right? Because I think this is really, there's like logical fallacies happening here. And I mean, so check it out, right? Okay.
Challenged, I believe, by the press at the time, and the full hearing was held on that, and the judge issued an order on that. The closure of the proceedings thus far have been consistent with that prior ruling by the court, for which the petitioning parties were given an opportunity to be heard previously. I don't think much has changed in terms of the need to protect the jury pool here, given
right there. I don't think much has changed in terms of the need to protect the jury pool here.
the intense media scrutiny that has and continues to follow with this case. Part of the rationale presented to the court yesterday for opening it was in order to.
So you guys see what I mean? It's like that to me sounds like he's just accepted that, like, that the jury pool has already been exposed, like nothing's going to change, right? In terms of their exposure. Either they've been exposed or they haven't, right? You guys see what I mean? Like, yeah, okay. So that's making sense to you guys. Awesome. So welcome to any new people here. So happy to have you guys. The Squirrel crew is awesome. We love all the our Squirrel family, and please feel free to join the Discord as well for anyone who would like. Denise is going to be our boots on the ground. Is currently in Idaho and has already downloaded and joined the Discord, so that she can keep us posted. So and are you referring to Steve? Oh, you're talking about, okay. So there's a Stevie B who comes in a lot that many of you guys I think are familiar with. And I was just making sure I have I know which Steve y'all are talking about here. But yeah, totally contradicted himself. Yeah, yep. Okay, so good. I'm glad it's not just me because I'm like, I don't, I'm trying to follow his rationale and I'm like, but I can't because it's contradicting. So.
For the defense to make their case to the public. That's exactly why it's not open. We will be challenged under the best of circumstances of obtaining a jury that is not been overly exposed to this, and in particular exposed to evidence that ultimately may not come into this trial. I am, as I told the parties yesterday, particularly sensitive about closing things when we don't need to, and I think that there has been to date a over caution in asking that I seal things by stipulation that perhaps don't need to be sealed. And I've asked the parties to stop that, frankly, and to provide better rationales as to why I should seal what they're asking me to seal. That
Well,
said, with
that I do appreciate. So, give him credit where credit is due. I do appreciate, because there's a lot of that. There's a fuck ton of that, right? The both parties just stipulate to sealing. And he's saying, because when they do that, he doesn't have to rule on it, right? So what he's saying is, let's stop doing that and actually make and provide me with a reasoning why it needs to be sealed. I agree. I do appreciate that. So yeah.
respect to in particular, the IGG issues, particularly where I don't exactly know what the evidence will be forthcoming, I am concerned about the potential impact on a jury pool. In this case,
that blows my mind. He's saying that as it pertains to the IGG, he doesn't know what the evidence will be forthcoming. Guys, how is that possible? How is that possible? How many closed hearings have they had solely for the purpose of talking about the IGG evidence, even just since he became the, judge on this case, right? And the documents, like countless, that's literally the point. That's the reason that they've had, what? I don't understand. Like, I could understand him saying that if it was like go back to the very first hearing, right? When he had just gotten, they just changed venues and he was brand new to the case. Okay, fine. You haven't had a chance to look at everything and to review the court record, and you haven't had any, nothing's happened, right, under your while you've been presiding. But I mean, even as of yesterday, right? Literally, the hearing yesterday that was closed was to talk about the IGG evidence. And the other thing is, right, the defense made the motion to unseal the briefings, right? And we're going to get to his order denying it. But even that alone, the only way he can make that decision is because he knows what is in there, right? Which again is common sense, because while the documents were sealed to us, he read them. I don't understand.
this case was moved to this court
Right.
because of the defense's
It
assertion that
literally makes no sense. Makes literally no sense.
they could not get a jury pool in northern Idaho that would be
And disease makes another great point, right? Again, we hear this all the time, right? That it's in high profile cases, especially, right? You can't go with a standard that to find a jury that literally no one's heard, like with an entire jury where no one's heard of the case, right? Because it's unreasonable. You'd never be able to see a jury, right? So therefore, as we know, they just have to be, they can be aware of it. It's just, the matter is, have you formed an opinion, right? You can have heard of it, you blah, blah, but have you formed an opinion, right? So, so another great point there. You guys in the chat say the best things. Y'all are so smart. Love it. But yeah, it doesn't make any sense. And honestly, if it, to the extent that that's true, if he's like, yeah, I don't know what the evidence is, well, then that's a problem, because how are you ruling on it so far? There's already been several things he's ruled on regarding the IGG. So are you not reading the briefings? Are you not listening during the hearings? Do you have like headphones on and you're just not paying attention? You're just like rolling the dice? Like, I don't know. What are you doing?
unaffected by the case, even with the non-dissemination order in place. The media here in Ada County is as, if not more, intense. And so I think there is need to be careful when we are addressing evidence that potentially is not going to be evidence in the case because of suppression motions in limine and the like, which is the concern that I have in particular with the Frank's hearing, as that does appear to be evidence that may not come in, and it may not be evidence that has been particularly disseminated to date. As I talked with the party, there are other issues that I've asked the parties not to address specifically as it relates to some of the motions to suppress that doesn't need to be discussed specifically. For example, the evidence produced by the warrants they seek to strike.
Okay, so what he just said there is that they've already agreed that there's certain things that they're not going to say. So in other words, what does this mean? Even the part that's going to be open, right, on the other motions to suppress, they've already agreed that there's certain things that they're not going to bring up. So right there, he has just I don't understand this. It's like he's making the case for the media because remember, they're trying to say one of the things is they have to offer solutions, right? Alternatives to closing it. Well, he just himself said, not only here's a solution, but we've already agreed. So right there, the words coming out of his own mouth solves the problem. That you go ahead and agree ahead of time. There's certain things that you're just not going to bring up. I mean, this already is so frustrating, right? It's like the fact that the portions that are going to be open, right? They're still going to not be able to talk fully about it, But however, if that's what it takes for them to do in order for more of it to be open, then it is what it is. Like, it's like choosing between the lesser of two evils here, right? Like, that's better than nothing. But the point being, he just said, here's the solution, but he's trying to say this as if that's a reason why it should be closed. I don't understand.
And for that reason, my intent has been and continues to be that we will have as much of this hearing open by way of streaming possible. I have not and will not open the courtroom itself to parties in the courtroom because of the need to close it if I find or the parties suggest to me, and I agree there's a need to discuss something at that moment outside the public's reach, which is easy to do by simply going offline for a minute. And that's what I intend to do tomorrow. In particular, the evidence with respect to the IGG.
Okay.
I think, at this point, it's appropriate to, and I will issue an order shortly, to keep that out of the public domain for the time being. Now, that may change down the line. My order certainly on the issue will ultimately give some information so that people can follow what happened from a legal perspective. But some of the factual details, until I know what those are, and I've seen that, I can't make that determination.
That is fucking impossible. Honestly, I wonder what other like judges and like I would imagine, like, if I were, I don't see how if you're his supervisor, right? If you're, I don't know, in Idaho, right? I think they're elected. My mind is just blown right now because it's like, if you're hearing this, how are you not like, you're like, get off the bench, right? Because this, like, what? It's as if you're the judge on this trial, for this case, but like, you're absent. Like, you're not, like, it'd be bad enough if you're just like not even reviewing the information, you're like tuning out at the hearings or whatever, but that'd be bad enough. But add to that, you're making rulings on the evidence that you're saying you don't even know what it is. So one of two things has to be true. Either he's lying, right? Either this is not accurate and this is false, right? He knows what it is, right? Or he's ruling on things that he doesn't know what it is, and he somehow is like literally not reading the briefings, and he's tuning it out at the hearings, and he's like which is the best option there, guys? I mean, either way, how is he still there? I don't understand. I don't understand. I don't understand.
Better. And so I think that this is the best way to proceed because I can't unring a bell once it is wrong with respect to potential evidence that in particular may not be evidence in this case. And so my intent would be to proceed with the evidence portion of the Franks hearing as it relates to IGG in a closed environment.
I think everyone expected that. So like, that's whatever, but
I think we can decide at that time before we go online whether we can have the IGG portion of the Franks proffer publicly. The intent is, I think we understood from discussion yesterday that the rest of the evidence and the arguments, both on Franks and suppression as it relates to everything else, we should be able to do public. If there's an issue that is specific, like Ms. Massoth brought up, about the need to mention a name that we need to protect from unwarranted harassment, which has been a concern in this case, we can certainly refer to them by initial, particularly if you give me a roster with initials or other identifiers you'll be using. then I can follow along. And I think that's the better way to proceed so that we can do as much of this in open light as possible. So I appreciate the petition. I don't think it has changed. I appreciate the defense has shifted its position to a degree here. I'm concerned that the purpose of the shift is to try the case publicly as was offered to me. That doesn't give me comfort, to be frank.
Unbelievable.
But for the meantime, until we can, I can get a handle on the exact evidence that does in fact come in, given that it is potentially evidence that will not be admissible, and anyone who hears about it may therefore be removed from the jury panel. I think it's better that we proceed in this fashion for now.
And I agree. I agree as well about this. Literally, I didn't pause it, but I was thinking as soon as he said that, I was like, wait, what? Why did he switch it? Because the suggestion earlier was giving them numbers, right? Random numbers. And it was like, yeah, that makes sense, right? But why did he switch it over to using initials instead? That makes literally no sense. It's almost like that's odd. Like it's like he went out of his way to change that when the initial suggestion was a much better system.
May I raise one other issue, Your Honor?
Briefly.
Thank you, Your Honor. So first, Your Honor, with respect to the non-dissemination order, respectfully, we represented the interested parties at that time as well. In our understanding of those proceedings, it was amended a couple of times. The second time after we moved to intervene and challenge the dissemination order then in place. And as I understood judges, the proceedings in front of him and the non-dissemination order, the purpose of that was to preclude extrajudicial statements and was not to preclude the attorneys
Right.
from.
She's right. The extrajudicial statements, right? Because he ignored that the first time she brought that up.
Saying things in court that would be made public. The goal was to make sure that there was accurate information
Yep.
for people knowledgeable about
Yes.
the proceedings, and that was the forum in which they could do it. And I would also note that Rule 3.6 does have sort of this rebuttal portion to it that allows if there is a statement that is made under Rule 3.6, the defense is permitted to make public statements to sort of counter that. And I think that's probably what the defense was getting at in its submission to the court. And then finally, Your Honor, are the court's statements in court today intended to be its specific findings regarding the manner in which the court is to implement the Press Enterprise 2 test, or will there be a written order so that my clients can be adequately prepared to decide what next steps to take?
Yeah, as I indicated, I intend to issue a written order following today's hearing. I don't think that what you said accurately reflects my understanding of the defense's position yesterday, but I appreciate that. I do understand judge's prior order to be dealing with extrajudicial statements because that's who he could control at the time, were witnesses and parties. But I also understand from a review of the record, there has been a concern throughout this case of exposure to evidence that may ultimately be inadmissible, and that prior proceedings were closed for that purpose, consistent with judge's ruling at that time. And I agree it would be an extension of that, but in general, I think that's where they've been throughout this case. So, at the end of the day, regardless of the outcome, the likelihood is everything will be unsealed. And before then, as soon as it can be done in a way that protects the case and the jury pool, which is the parties' rights, both parties' rights to a fair trial is paramount, as is the public's right to know. But I also have to weigh that against the ability to have a fair trial by getting a jury panel that has not been tainted by the publication of widespread publication of evidence that may not be admissible at trial. So it's a bit of a narrow path for the court to have to tread, and I appreciate that, and I appreciate that that calculus isn't always in the direction that one would hope, but I am doing my best to make that calculus in a way to ensure the rights of the parties and to ensure a fair trial, and that we can do that as quickly as possible. All right, so I will issue an order forthwith, and tomorrow we will come forward with public hearings just as soon as we can. Further, if after hearing that evidence, I determine it doesn't need to be protected, I will order a transcript be prepared, and I will order that be produced. But in the meantime, I think I need to take this course, so I appreciate that. Thank you.
Thank you, Your Honor.
Okay, I'm just pausing that. Give me just a second, guys, for something. So here's the thing. As it pertains to the IGG, let me find it. let me just take a look here and find this. Give me just a sec, guys. Is this okay? Hang on. I think. Okay, hold on. So I'm just looking for this. Okay. Yep. Here we go. Okay. Let's do this. Let's do this. I didn't have this. This wasn't like a planned thing. So otherwise I would have had like a thing ready to go. Sorry. Okay. So, but as they all say, right? Streaming is dynamic. But here's the thing. I think that the best way to go over some of the stuff pertaining to the IGG is to do this. So, okay. Let's see here. So this is a live stream from, I don't know, sometime a week ago maybe, but it's from when the defense first filed their motion to unseal the IGG, okay? But let's review. So this, again, I'm pulling this up from a previous live stream, but this is good review for those of you guys who saw it, but if you didn't see it, because there's just so that we can discuss in terms of what have I sort of found and how am I understanding this IGG information, okay? Because, is it IG? Is it not IG? And what's the dealio? So, okay. So we're going to pull this up here. Where is it? Gabriel Vargas. Okay, the loopholes. Okay. Okay. Let's see if this is right.
There was.
He's back. What?
There are a lot of tools that are available in GEDmatch. Once you run their matches, there is a tool that allows you to edit that list of matches. When you edit the kit list, if you put the subject's kit number into this tool that you're going to now analyze, these matches, it tricks the system and allows you to see matches that you wouldn't have seen if you ran your initial match list. And those can be people that did not agree with law enforcement to see their DNA. Those matches that are revealed are only matches that have been opted out.
Okay, so loophole number one, right? So that they can see the matches of only people who opted out. And instead of playing loophole number two, I'll just review it for you guys, which is loophole number two is actually kind of simpler. Law enforcement just simply registers on a DNA database as a consumer, and then they can see everybody, including those who opted out. Okay. And so there's that, right? Okay. So then, okay, hold on. Okay. Trying to back this up a second here. Okay, this information so they can see if the lead was correct. I mean, so again, this is from a live stream, that's why I'm talking, so it's like double talking. But okay, so basically what's on the screen here, right? So much of the information relied on by the FBI was only viewed through the user portal and the publicly available genetic genealogy services and other investigative databases. The FBI did not download or create copies of those records, right? So, okay. So that brings us to the next question here. here. So where did the IGG discovery come from, right? Like what I was looking for was I'm just fast forwarding this, but this is from a previous live stream. This is just the only way for me to find all this information that I worked on before. Okay, so the charts. Okay. So so take a look, guys. This is from the state's reply. No, wait, hold on. Yes, the state's reply to the defendant's objection to the state's motion for protective order. And so let's take a look at this. And we're going to put it on with the timeline. We're just going to review some of this stuff. So, okay. So K-bar at the bottom, knife sheath, right? Take a look. So S&P profile created by private lab, likely Othram. Crazy thing here, if you take a look as well. Look, they entered the DNA into CODIS after they sent it to Othram, which is also, I mean, it's not that it's illegal, but like it's, well, we've actually, again, we've already covered this on previous live streams, but it's not what you're supposed to do. You're supposed to submit it to CODIS first. That's like part of like the rules. It might be part of like the DOJ interim policy, but also it's just common sense and goes without saying. Anyway, like that blows my mind, right? That's where this is according to the state, right? This is where they put it. That's why I circled it in red. Okay, so remember, right? The IGG research was initially started by the private lab, okay? And so the whole thing about November 29th, that's the Othram invoice. And that's, well, actually, we'll get to the calendar here in a second. Here. Okay, so on the 29th, Othram invoice, and that was the same day that whole crazy thing with WSU and querying the Elantras, and then 30 minutes later in the middle of the night, a different officer happens to stumble across a white Elantra belonging to Bryan Kohberger. So, okay. And then you have this. On the 16th, Bryan Kohberger is observed by law enforcement at a CVS in Pennsylvania. Okay, I'm just trying to get to the next slide thing here. Right, okay. So then on the 19th, the state identified BK through IGG, right? As in, that's when they were told by the FBI, like that was what happened, right? In my view, that's when MPD took back over the case, is on the 19th, because that's when they got the quote unquote tip, right? But the state identified BK through IGG. Okay, so then, and you know, of course, like the FBI had already identified him, as we've covered it, but we're just kind of doing like a little overview here because I wanted to get to some of this other stuff related to the IGG. And then back to this. So, okay, let me go to the beginning of this chapter and just play this. So what if a suspect has submitted, this is the thing, what if a suspect has submitted DNA to an IGG database, committed a crime? But when you include in that everybody who's also opted out, what you get is everybody who's ever used any of those databases with their DNA, right? You get the opted in and you get the opted out, which means that's everyone who's ever submitted DNA. And so that question of it's just a matter of time, like what's going to happen when somebody gets a match to themselves, that speeds that process up. If you say, well, now even the people who opted out, I mean, I would imagine probably more people opt out. I would imagine what I was talking about here is that when you look at the calendars, like, you know, the homicides happen, right? Where's the Othram invoice? I had that pulled up. Let's see here. Othram invoice. Partial family tree. Right. That's actually really important. Let me click on this here. hold on. Right. Okay. Here. So in this case, investigators used IGG to begin the process of developing a lead to the individual. Idaho State Police utilized a private laboratory to develop an S&P profile. The private laboratory started using genetic genealogy to develop a family tree. But after law enforcement decided the FBI would take over, the private laboratory ceased its efforts and sent the S&P profile to the FBI. And the question I've asked on previous live streams is why? Why did they enlist the private lab and then law enforcement decided the FBI would take over? Interesting, right? And then there's also this footnote that should pop up here in a second. Right here. Partial family tree created by private lab. Partial. So, and as we heard and we covered it with the way that it's described, right, with Gabriel Vargas, that when they start working these cases and building these trees, they take over the case and then they work and then they turn over their lead at the end, right? And this takes a lot of time and they're building a family tree and you guys already know. So this is why this is interesting because they start, right? They have a partial quote unquote family tree and then FBI says, no, we're going to take over. And the thing is this is where I was looking for the author invoice because I'm sure it's in here somewhere. Well, the author invoice. So the author invoice is from November 29th, right? That's the author invoice. So that would be like they're not working on it anymore, right? And so you've got, if you imagine, right, the homicide's on the 13th, right? Even if you, in the best case scenario, let's say that they get they're able to extract the DNA quickly, which sometimes they can, right? And get that S&P profile sent over to Othram. Othram still, I think when we went through this before, at most they could have had it for a week or something like that. And they have to develop an S&P profile, right? They have to develop an S&P profile. So essentially, like the thing is this, when you look at how much time they had, and then the fact that they were told to stop working on it on November 29th and had a partial family tree. Okay, so now let's go to this part here. Okay, the whole thing is this, right? IGG is technically this process, right? Where you build out a family tree and you, what I'm getting to here is why technically I don't think IGG was actually done in this case. It takes time. It takes time. And that's how it all started. The way it all started was because the reason that it started is because there was a need to do that. Why was there a need to do that? Because at the very beginning of all this, right, whenever these sites first started, these direct-to-consumer databases, there weren't that many people that had submitted DNA. So what happens is the more over time, right, as more people submit more DNA, you have more, it speeds up the process, right? But the whole point of it was because however many people are on the planet, right? And then if you submit your DNA, you're one person out of however many people are on the planet, right? It's like the whole point is that it's going to take time to try to get these connections and to have more relatives identified. And it's going to take time also, as in time for more people to just choose to use one of these, So again, so the idea, like IGG in its inception is all about using a family tree to identify people. But again, so what am I trying to say? What am I trying to say? Without anybody having known, right, that maybe eventually the point of it, right, is not to get a direct match. This is the point. Listen, the point of it is not to get a direct match. The point of it is that you're going to get a family and all that. But just because that's the point of it doesn't mean that it couldn't or wouldn't eventually happen. A direct match. And that, again, those odds increase as more people have, you've got people committing crimes, right? And then as more people have submitted DNA. So in other words, that's why I kept saying IGG in scare quotes, right? Because essentially, like, for example, again, I've done this myself, right? So for me, if I went back, if I pretended I didn't already submit my DNA, right? Or if I pretended I was someone, if I went in there, right, and submitted it again, right, onto my heritage, whatever, like, I would get a direct match to myself. Are you guys seeing what I'm saying? Again, this is from a previous live stream, but because I did this, right, my heritage, like, if I submitted it again, I would get a direct match to myself. This is the point that I'm making here, is that the point of IGG and the inception of it was never expecting that. It was, the whole thing was because you can't get a direct, because you're building a family tree. But the thing is that as it has grown and more people are submitting DNA or whatever, right, the odds increase, right, that somebody would be a direct match to themselves if they've submitted DNA. Like for me, right, like I said, I would get a direct match to myself. So even though that wasn't the goal of IGG, that doesn't mean that can't happen. And literally, I've been thinking this ever since I first submitted my DNA to that. That was before this case even started. I literally thought to myself, I wonder what would happen if somebody is a suspect in a case and they have done this and they match themselves. And I was like, oh my God, I feel like the whole world would implode if that happened. Like, I literally thought, there's like, that's such a crazy thing to think about. Like, I can't even go there. Right. And like, but at the same time, I'm like, but literally that will happen eventually. It's a matter of time, right? Because I've already submitted my DNA, right, to it. So I would get a direct match to myself. So I would not, that wouldn't count as IGG. Why? Because IGG involves an investigation. It's investigative genetic genealogy. It's, the whole thing is IGG is building out this family tree, right? So it's like, if I just use an IGG website, but I get a direct match to myself, it doesn't mean that I've partaken in IGG. Does that make sense? Because the IGG is the family tree part of it. So that's why I've been saying IGG in scare quotes. And so, and that would be, it would be true for anybody. True for anybody, right? If you have an S&P profile and then there's a direct match, you don't build a family tree, right? That's the point. Here's one person, bam, right? There's your tip, quote unquote, right? There's your lead. I mean, and I say that again, because it really is a lead. The way this normally would. So the thing is this, right? So let me go forward a little bit. Because how did this happen so quickly, right? And kind of what I get to here is like that law enforcement essentially might have just gotten lucky in a way here. Okay. So am I making sense to you guys? So in other words, could Bryan Kohberger have been a direct match to himself, right? And if that's what happened, I wouldn't. If that's what happened, it would explain a lot of things. Here's what it would explain. It would explain. It would explain why Othram was so quickly to get a result, right? Because by November 29th, how did everything happen so fast? This is the amount of time that elapsed, just by the way, is not enough time to actually do IGG, right? The whole thing about the family tree, that's why I kept saying, you know, hundreds of relatives, like it takes months, if not years. So anyway, but never mind that. You got homicides on November 13th. Again, we don't know the date that the extraction was finished. We don't know the date the DNA was sent, right? But it was after November 13th. And by November 29th, we have a result from Othram, right? They took the S&P, they put it into the database, they got a result. That result was given to the FBI. And only 2 weeks later, the FBI is following Bryan Kohberger in Pennsylvania. So if he was a direct match to himself, it would explain how the hell any of this happened. Explains everything, timeline, right? And it would explain why they were asked to stop and for the FBI to take over. Because you see what I'm saying? Like, that's why this question is up here. Like, if they got a name, if they got a direct match, well, they're done, right? Job done. And then the other factor there is if it's somebody, if that's what happened and he had opted out, right? Then the other question, why would the FBI take over, right? So if there was a direct match and he opted out, why would local law enforcement later on benefit from that? Well, because of what we already looked at. What happens when they ask the FBI for discovery with the IGG? Right? We don't have it. We deleted everything. We don't have any records. We have nothing to turn over. So the last thing I would say is this. So why, I don't know that anybody's asked this question. The question then would also be, right? Why was it that the name, right? Look at the top of this picture. Why was it that the name, the defendant's name, was not provided to local law enforcement by the FBI until December 19th?
This is important, I think.
Why? Like, why is that? So remember, the FBI has gotten this stuff a long time ago. They turn it over to local law enforcement on December 19th. And meanwhile, prior to December 19th, they're doing whatever the fuck they're doing in Moscow, which is just, you all know. They're looking for a white Elantra and searching WSU data, whatever. So, and remember, there's a lot of things that happen on November 29th, right? Because that same day is the day that you've got the WSU queries and all that. But anyway, I don't want to, we could talk more about that, but let's stay on topic. Well, not that it's not on topic, but anyway, let's stick with the first question. So why would they have waited, right? Oh, that's hilarious, Heather. So if indeed, again, if you go with the thing, what if Bryan Kohberger was a direct match to himself? And what if he had opted out? Or what if the FBI, utilized one of those, they did a search as like a consumer, right? They broke the rules, they did all that, like the stuff we already talked about. What if they did one of those things? Then potentially, would there then be a need to try to make it look like that didn't happen? For all the people who've been asking the question of, when you look at all this stuff, it looks like the FBI was actually working this case, right? And MPD was like, it's like a parallel, like a dual investigation, right? Like the FBI was actually doing the work and MPD was just like, whatever the fuck. And then, and then they take the case back over, right? And for everyone is like, why though? Like, what's the deal? So this is what I'm offering a possible explanation for, or a possible explanation of it, right? That is what I'm actually about to get to here in this live stream, right? About that could be resulting from if Bryan Kohberger had submitted his DNA previously, right, to a database, and if he was a direct match to himself, and additionally, if potentially law enforcement used one of those backdoor, if he had opted out, right, and they backdoored it, okay, then more time needs to have elapsed, right? Like if you broke the rules and you got a result right off the bat with who it is, but like everyone will be like, well, how did that occur, right? Like how the hell did, like, obviously that's what the whole point is, right? It's like, how did that happen?
But, and the only way you can answer that would be then also you would have to admit you broke the rules, you broke the law, whatever, you know, you did all those things. If you're the FBI, right? So maybe the answer there is you delete all your work. You delete all the stuff. You have nothing to show. You have nothing to show for what you did. And you wait to turn the name over to local law enforcement until after it looks like maybe they've done enough.
Yeah.
To where it looks like they could have found the suspect another way.
Do you guys see how this explains, at least in my view, this explains literally everything that we're seeing, right? Of like what, like, imagine for a moment, if you will, that, you know, again, they essentially, again, this is why I said maybe they just got really lucky. Imagine, if you will, for a moment, that they submit it into a database, right? And they get a direct match. And and according to what we have, that would have happened really quickly. And even according to this own chart that's on the screen here from the state, it's like before they even searched CODIS, right? But the November 29th, and imagine if they got a name then, right? Like, you know, job done, as they say in England, right? Like, in other words, they're supposed to be doing an investigation, but they've got a direct match. And so if you're law enforcement, and then you're like, well, that's who did it, right? That's what they would think. So do you see why now there's almost a need to like try to make it look like you're doing an investigation, because you don't really need to, but you have to try to make it look like you did, because potentially, again, if we go along this line of like, what would have happened, right? If they backdoored it and they got a direct match and they're like, oh fuck, right? Like they wouldn't have been expecting that. Again, getting lucky. And then it's like, well, now what do? You have to essentially try to cover that up. So what do? You delete all your work, right? FBI deletes all their work off the, we don't have anything to turn over, right? And then and meanwhile, MPD is whatever the fuck. And then you wait long enough and you try, and do you see how this would explain though, why this question from the get-go has been, how did they get to him? And the whole thing about the white Elantra is just a disaster. And there's not really anything else, right? Do you see why the white Elantra, if anything, is just the like scapegoat, if you will, or like what's the word I'm looking for? It's like the thing that they're using to rely on in a way to try, because they needed something else. Like the way that they actually got to him, from what I can tell, right? They can't say that, right? And then you have a whole other separate issue of this whole thing of like IGG, right? But it wasn't actually IGG if they never built a family tree, because they didn't need to build a family tree. So is this making sense? Like, this is why, like, when I look at the timeline and I look at all this stuff, and I have a bunch of other stuff in this presentation too from this other live stream, but yeah, a direct match would only be legitimate if the person was opted in. You see why that's a problem? A direct match would only be legitimate if the person was opted in. Do you see why they have it's like they got really lucky potentially, but at the same time they fucked themselves. That's what it is. Because now what do? Right? It's like if he was opted out and he had submitted DNA and he was opted out and they backed, and so that, like they have the answer, but like they fucked it, right? It's completely fucked. And so now they have to try to create an investigation to try to show how they got to him so that they don't have to say how they actually got to him. Is this making sense? Yeah, Jeff, welcome. I guess you just got here. Literally, I've just been explaining my thoughts on this exact question, but you might want to back it up a little bit. Literally, thank you, Need Some Z's. That's literally, it's because it's not a simple answer, right? That's why I was like, as I see these questions come in the chat, that's why I'm like, okay, I'm going to have to just pull up this live stream, because in this live stream, I had a whole presentation. I mean, it's like a 6-hour live stream. I had a whole presentation that outlines step by step how I arrived at the thoughts that I arrived at and what I'm talking about. And right now I'm just trying to go through it and give like an overview, if you will. But I will link this live stream in the description of this video for you guys who want to go through it and see step by step how I got there. And everything will be timestamped, as always. Well, it's already timestamped actually, because this was from like a week ago. So, but this outlines literally how I think that this to me explains everything. If this is what happened, it explains the timeline. It explains, and it explains the problems in the affidavit. It explains why it's IGG but not IDG. It explains why. It just explains all of it. The list would go on and on. So let me see what else I have on here. Right. So yeah. So a direct match would only be legitimate if the person was opted in. And then Heather here, again, I'm just going to go to this because she has a comment here that is, the point is that the same day that Authormoth created the invoice for the IGG is the same day that they physically located his car. Yep. And then again, I have calendars pulled up here. And then when did MPD kick FBI off the case? So my conclusion there that I go through is my thoughts are that it was November 29th. December 19th, right? December 19th. That because that's when they kicked them off the case because they got the name. And then we went through this whole awesome article from the Journal of Law and Biosciences. And then that's when we got to another great exhibit. I'll pull up for you guys here. So where's the exhibit? IGG step by step. Check this out. Okay. So this is from the Law Journal article thing. Okay. And so unfortunately, see now, let me do this. Let me mute it. And then I'm going to play it so that way it doesn't cover up anything on the screen. Hold on. We'll see here. Wait, play. Okay, so this is this exhibit from that Law Journal article. So basically what I'm sure I'm explaining is that this is showing step by step how you're supposed to do it. And so step one, well, let me just do this. Because this is going to drive me crazy because it's covering up some of the exhibit. Let me just pull this exhibit itself up. Hold on. It'll just be one quick second because this is important, guys. This is important. Hold on. Okay, so let me pull this up here. Okay. So I just have to unshare, reshare. Okay, so here I have a side-by-side of the state's DNA tree, as I call it, or IgG tree rather. And then this is how it's supposed to be done on the right-hand side. But let's take a look at the right-hand side. Well, let me see. Can I make it? Let me just look real quick. You guys can take a look at this while I look and see if I've got another version of this where you can see it better. Just one sec. Where? Gosh darn it. I don't know where it is. Okay. So basically though, it's color coded, right? So in red, you've got, if you have the DNA, you put it into CODIS, direct match, right? And then in blue, you have, and you guys hopefully can see the mouse, the hand here. In blue, you have, if you already have a known suspect, right? So like you already have, like, so in cases, for example, where it's like, it looks like it was a family member, whatever, you have a known suspect, right? And then one-to-one matching. One-to-one matching is a direct match via a buccal swab, right? So again, in red, that's if no suspects. So if you have no suspects, you put DNA, STR DNA into CODIS, direct match. If you have a suspect, then you can get their DNA via the buccal swab, one-to-one matching, direct match, okay? In yellow is IgG, okay? Step 2. Now notice again, already, right? Step 1, you put the DNA into CODIS. Now look at on the left at the states tree, right? They did it the other way around. They submitted DNA to Othram before they put, according to the state on here, before they put DNA into CODIS. Okay, that aside. Again, back to on the right in yellow, right? If all suspects ruled out and no leads. Let me say that again. If all suspects ruled out and no leads. Not step 1. This is not step 1, right? This is, yeah, okay. This is step 2, right? Then you go and you get an S&P, right? And then begins the genealogy process, right? Step 4, investigation. And now the amount of time that normally would elapse here would be substantial, right? And then after that, then you have STR generation, so one-to-one matching. That means that you've got the tip eventually. After the time has elapsed, then you have a buccal swab, and then you get a one-to-one matching. So the reason these things, the red squares here in the middle, is to show that's where in each of these situations, that's the point at which you have a direct match. Okay. And so again, what no one anticipated is the different is you put the name in and to the database and you get a direct match there. And then you get a direct match with a buccal swab. Right. But that's how you get to the name. So, but we went through all this from that Law Journal article in great detail. Again, I'll put the link for this live stream in the description of the video because we broke this down like in great detail. So, okay, but let me do this. Let me go back. Let me unshare, reshare here. And go back to this. So hold on. Hopefully I'm not confusing anybody. Hopefully this is making sense. It's hard for me to kind of keep up with the chat. I'll take a moment here and look at it. Let me just get this pulled up for you guys. And then I'll take a look. So, okay. Because, just sort of like going through all this. So yes, okay. Shout out to everyone who's new as well. Welcome. Let's see here. Yeah. And so my point, what I was just discussing too, as far as the investigation, right, is that they didn't, remember, if they got lucky because they put the DNA into CODIS, or sorry, not CODIS, sorry. Othram gets the S&P and they go on and they put that into the database, right? Maybe potentially using the backdoor step, as we already talked about, right? If they got lucky and did that and got a direct match to Bryan Kohberger himself, the investigation's over on it, like practically, like they don't, like in their minds, they have their guy, right? Because they have the name. And this potentially could have been on or before November 29th, right? So then, again, like I just explained, then you have, though, the need to make it look like that didn't happen because you're fucked, right? So then everything else is like to try to make it look like there's an investigation, but you're not really investigating because you already have the name. And we know that the FBI was in Pennsylvania following him to the CVS on December 16th, right? You see what I mean? So like they had their name. They had their name. And so there, like, if that happened and they got lucky, there wouldn't be a need, again, in their mind, like, to keep investigating. It would just be to try to make it look like you're investigating. Is that making sense? So hopefully that is helping you guys. So by that. So and again, when you think about like the whole thing about the involvement of the FBI, right? And then they delete all their work, right? They delete all their work, they turn over the tip. And again, like I said earlier, why would they have waited until December 19th to turn the tip over? Again, they had to potentially buy time, right? For MPD to do enough, whatever they were doing, plausible deniability, right? And then also to make it seem like potentially there could have been enough time to build a family tree. The funny thing is this, though, it still wouldn't have been enough time, but it's better than like the 1 week that it actually would have been, right? Like that's better than the actual situation. It's like their job now, right? Again, if they got lucky, they got a direct match, right, through the DNA database. They've got the name. They're, again, in their minds, job done. Their next job is now not to look for the name because they got the name. Their next job is to try to make it look like that didn't happen. You see what I mean? They would have to work. They would have to try to do everything they can to hide how they got the name because they know they're fucked if that comes out. Because if you do that whole thing, you backdoor it, right? If he opted out and even if he hadn't opted out, right? The whole direct match thing, again, no one would have anticipated, but it's only a matter of time. And again, in that previous live stream, we also brought up something that talked about that too, where somebody in one of these articles was like, mentioned that it was only a matter of time, which is really funny because I had been saying that, right? I'd been saying that it was only a matter of time before this would happen. And we know that this is a case of first impression. The other thing that we know is we know that Ann Taylor said that in the IGG briefings, there's no family names mentioned. That's the other thing. No, let me pull that up for just to hammer this point home, guys. Let's do this. Check it out. Check it out. So that live stream that I was just going through, that presentation, that happened, I think, before this came out. But anyway, here, look. No names of the extended family tree are discussed in the briefing. Why do you think that is? Why do you think that is? And so based on everything I've just gone through, I would not be surprised if it's because there are no names, because there is no family tree, because there was a direct match. Right? I think this is just my personal, again, for anyone who's like this isn't just like I don't just like there's a lot that went into me formulating this, what I'm just explaining to you guys now, but I'm just summarizing it. But if you want to see how I got there fully, again, the previous live streams will show you that step by step how I got to how this over time, right? I scrolled at it, right? I scrolled at it and I'm like, I did all this work. I did a lot of hard work to get here, right? So, but to that extent, right, all of that all that hard work and everything that I can see here, what that says to me is that the quote unquote extended family tree is literally potentially just one name because it was a direct match. Again, because I can say I did this myself, right? I submitted my DNA to MyHeritage. If I were to do another DNA test and send it back in, I would get a direct match to myself. And that's true for anybody. And again, here we also have the added thing of like the opting out and then the backdooring. So, but the whole point being that whether they backdoored it or not, you know, if he had submitted DNA, it would be a direct match. And they would, when they put it in, instead of this whole family tree and all this and all these, they would get one name. And then there is no family tree, right? So, okay, but now let's do this. Okay, hopefully that helps, guys. So, or hopefully, I mean, that just gives you some food for thought too, and possible. I think it offers an explanation to a lot of things, as I've said. So, and it's funny because it's actually a really simple solution, right? But because it's such a problematic simple solution, it also explains why everything seems really complicated, right? Why does it seem so complicated? Because that, yeah, anyway, I've already explained. So, okay. So now we're going to get to the objection. So this is the state's objection to the defendant's motion to unseal. So these all just posted just hours ago. But this was filed on the 17th, but just posted. Okay. So the state does not oppose unsealing the IGG suppression briefing and record of the hearing, but the court should wait to unseal until after the trial. Oh, this is so stupid. What a dumb argument. Like, it's like trying to make it look like they're being agreeable when the whole purpose and the reason the defense was asking for it was so they could use it at these upcoming hearings. Anyway, okay. As defendant notes, the national and international attention in this case have led to the sealing of many pleadings. Look at how they put, look at this. Look at in scare quotes, Jesus Christ. As well as most of the evidence. As defendant also notes, sealing of those records have been proper under ICAR 32. The rule expressly contemplates sealing information temporarily when it is necessary to preserve the right to a fair trial. They put that in quotes as well. The state does not think it is wise to change this practice so close to trial. Defendant argues that this court is required to unseal the IGG information pursuant to his right to public trial. While his right to a public trial can extend to a suppression hearing, that right is not absolute. A court can close a public hearing, including a suppression hearing, if there is an overriding interest that it is likely to be prejudiced. The closure is no broader than necessary to protect the interest, and the court has considered reasonable alternatives. And again, in my view, the thing that would be neutral, that would also be a common sense thing, is this part, right? What, like, in other words, whether you're the state or the defense, like this applies to the court, as in Judge Hippler, right? Considering reasonable alternatives. That seems like a really good solution that everyone should be able to agree on, as in both parties in the case. The need to protect the jury pool in a high, interesting, because this is like what Judge Hippler echoes. So Judge Hippler echoes in that hearing we just watched what the state is saying here, which again, to me was, I was not actually even expecting this argument, because that's where I'm at with this. Like what? We've already covered this with the jury pool. Like, by we, I mean they have. Okay. The need to protect the jury pool in a high profile case where the evidence considered may not come in at trial constitutes an overriding interest that satisfies the Waller test. As the U.S. Supreme Court has recognized, publicity, blah, blah, I'm not going to read all that. Okay, here we go. Inform potential jurors of inculpatory information wholly admissible at trial. That risk does not automatically justify refusing public access on every motion to suppress. But this is not a routine motion to suppress in a routine case. The risk of exposing jurors to information that may be deemed inadmissible is particularly strong here, given the publicity this case has received and the fact that most of the evidence in the case is still under seal. In fact, the defense has not only acknowledged the uniqueness of the publicity in this case, that this case has received, but has affirmatively argued that publicity has warranted shielding from public view information that would be available in a routine case. The non-dissemination order was justified. And again, he brought that up in the hearing as well, justified to protect against adversely affecting the integrity of the case to be presented at trial, because this case involves matters that have received a great deal of publicity. And the unsealing of a hearing in particular increases the risk of tainting the jury pool. So really, so now this makes more sense. Judge Hippler literally echoes like almost verbatim, like literally what the state is saying here. And that would explain why Judge Hippler didn't make any sense. Remember when we were all like, what? This makes no sense. He's contradicting himself. It makes sense when you think, oh, he's echoing what the state said. Okay, now it makes sense because that's what the state does. So yeah, now it all makes sense, as in it didn't make sense, and now we know why. Okay. Unsealing the IGG information before trial is particularly problematic because even setting aside the pending suppression issue, there are still questions about the extent to which IGG information may be presented at trial. What? Wait, what? What? Okay, hold on. Stop everything. Did you guys hear that? What? How many times have we heard from the state up until now that they're not using this at trial, right? I mean, I thought that was a done deal. Like it's just an investigative lead. It's not coming at trial, like, right? And in fact, all of the literature on IGG even says, like, you know, it's not to be used at trial. I guess it doesn't say that you can't, but it's like, that's not the point, right? And I think that they even say that it hasn't been used in a trial yet. Again, that would have been in that Law Review Journal article that we covered in the live stream that will be linked in this video's description after the fact. But are you guys hearing, like, what? Look. Let me read it again. My brain is buffering on this. This is insane. Unsealing the IGG information before trial is particularly problematic because even setting aside the pending suppression issue, there are still questions about the extent to which IGG information may be presented at trial. What's happening? What's happening? What's happening? You got, is he saying, okay, I wonder if Santa is saying this because he's, yeah. Okay. All right. Here's what I think is going on here, guys. The state is running, in my opinion, running out of argument. By argument, I mean argument to the court, right? Arguments that they can make to keep this sealed. Remember, their initial argument was all about the family tree, right? But that was before any of the discovery had been turned over. That was before, like the motion for protective order talks about the hundreds of innocent relatives. All that happened before the IGG hearing, which was in August of 2023. And that was, so at that point, nobody had seen, like, as a judge and the defense team, the point of that hearing was to say, you need to turn what you have over, right? So nobody except for the state had seen what they had. All of the languaging about the extended family tree and all the innocent relatives and whatnot, that was from the motion for protective order, right? So in other words, they're saying that, and that's before no one else has seen what they have, right? They turn it over, you know, and so my thought was like, that was their first way to try to keep it from being turned over and to keep it from coming out, because they're like, okay, the extended family tree. Remember, in my what I've just gone through, I don't think there is a family tree, but I think that's the argument they were making because they know that's an argument that has been valid in other cases. And it would be a valid argument if there was a family tree. Anyway, so that argument's, well, let's just say that's shot down because now things have been turned over. Remember, again, like Ann Taylor said in that motion to unseal, what did she say? There's no names mentioned, right? There's no names mentioned. Okay. So that argument is shot down. The whole names of people. Okay. Now the state needs other way. They're going to have plan B, plan C, plan D. Okay. So, you know, I don't even know which letter this would be because we've covered other of those backup plans before, but I think they've just reached a new level of where they're running out of things. They're running out of options. So they're at plan, let's just say plan J, okay, of trying to keep this shit under seal. This is what it is. Because look, we know that. So what are they doing? They're now saying they're doing a 180 and saying that IGG information may be presented at trial. I'm flabbergasted. The only reason they would be saying this is because it's again, Plan, what did I say? Plan J. They're running out of ways to keep this sealed. Oh my God. Oh my God. Oh my God. That's true. So a list of initials. But remember, it was also weird too, right? Because the suggestion was for numbers. And it was weird when he said he changed it to initials. We pointed that out earlier because it was like, why are you changing it to initials? When the suggestion was to give them random numbers, and that was a better suggestion. Right. And that's the other thing, right? The fruit of the poisonous tree, well, that's the whole point, right? I mean, everything that I've just explained about, well, my thoughts on what it's IgG, but it's not IgG, right? It's still easiest to call it IgG because that's what everyone understands it to be, so that people know what you're referencing. So I'm still calling it IgG, but it's not actually IgG if they didn't build a family tree, right? So it's more like the information from the DNA database, right? The direct match potentially, and potentially backdoored it, right? There's no case. Like, that's it. The poisonous IgG tree. The poisonous IgG, not IgG tree. That's what it is. So yeah, but I am curious what those initials will be. I am curious about that. And we don't know yet what that's in, like, maybe I'll pull that back up after I finish reading the documents and see, because it could be too that that's for other things. I'm just curious. I'm curious. Well, I mean, we'll learn more tomorrow, but maybe I'll pull that hearing back up and go to that part again with the initials and see what they're referencing. Because we already know that, like, they're not going to be talking about IgG, right? So absolutely agree with you, Rochelle. Yeah. I mean, the thing is, right? Remember, like I said, if this idea that is accurate, right? That he had submitted his DNA, Bryan Kohberger had submitted his DNA, whenever. Potentially he opted out, potentially law enforcement backdoored it, and they got a direct match because they got lucky, but literally unlucky at the same time, right? Again, their whole thing now is to try to make it look like that never happened. And the challenge is that they already know, you know what it's like? Let me give you this example. I've been waiting to come up with an analogy, and I've just got one. You guys, do y'all remember when you were children, when you were kids? Did you guys ever snoop and find your Christmas presents ahead of time? Did you ever go find, especially if they were wrapped and hidden, did you guys ever go snooping around as kids and the present was wrapped and hidden? Okay. And let's just say it's, I don't know, whatever, some amount of time before Christmas or whatever holiday or your birthday, whatever. Did you guys ever do that? And it was exactly what you always wanted, right? And now your new job, instead of daydreaming and wondering what's in the box, what's in the present, what's my present, right? That's what you would have been. That's what I was, always thinking. What am I going to get? What am I going to get? So now you know what you're getting. So your new job has changed. Your new job is now to make it seem like you don't know the answer. Well, and also your new job is to try to make it look like you didn't unwrap it, right? So now what do you have to do? You have to try to fold the wrapping paper back up and tape it and make it look like, you have to make it look like, and then you have to make sure it's in the right hiding place, right? And if it was well hidden, that can be hard to do. And if my parents were the type that they would make it to where it's like they would have a little thing, a thing where they would know if someone snooped, right? So it was a whole thing. So you have to make it look like you didn't snoop. You have to make it look like you didn't unwrap it. And then on Christmas Day, you have to make it look like you didn't know what you were getting when you already knew what you were getting. That is what this is to me. That's what this is to me. That's the analogy I've been waiting for. And my brain just came up with it. That's the analogy. So do you see what I mean? Like, that's what I think went on here, in my opinion. And so it's almost like, again, it's almost like you're worse off, right? And did you guys ever have it happen where because you snooped, they didn't give you the present? Did you guys ever have that happen? Because you snooped, they didn't give you the present. So you're like, initially you find the present and it's what you wanted. You get all excited. You think and you get lucky. And then turns out, uh-oh, I just screwed myself. Now I don't get the present. That's what will happen in my mind if the IGG information comes out. No present. No more presents for you. That's what it is, in my view. Right. Rochelle says, yes, then ended up getting something else because my mom figured it out and had to act surprised instead of pissed. Yup. Yup. Do you guys see what I mean, though? Do you guys see why this is like, you know, it's a lot at stake here, right? But that's a really good example of how you can think about it. You know what I mean? Like the white Elantra is like, you know, trying to, like, let's just say that when you snooped and you unwrapped it, let's say that when you did that, you tore open the wrapping paper in a way that you couldn't salvage it. And let's just say that your parents had already used all that wrapping paper. And now you have to try to find a duplicate wrapping paper. Let's also say that you're a child, so you don't have any way to go even purchase wrapping paper. And you've got to try to find a similar wrapping paper and make it look like it was the right wrapping paper all along. I mean, good luck with that, right? Like, you're fucked, right? Like the white Elantra is like the wrapping paper situation. You know what I mean? It's like, so now you're like hard at work on this other thing that literally is irrelevant just to try to make it look like you didn't get lucky and find the present. That's what I think. Okay. So the state plans to raise the issue in a forthcoming motion to eliminate, but if the court finds all the IG information inadmissible, unsealing the IGG briefing and holding the hearing in public view presents too great a risk of tainting the jury pool. None of this makes any logical sense. This is just, you guys, if nothing else, here's how I am interpreting now when the state talks about IGG. Because again, I don't think there actually was actual IGG because that's a family tree, right? It's just word salad. It's literally just circular reasoning and logical fallacies. Look, this paragraph right freaking here, guys. This paragraph is the state scrambling to find freaking more wrapping paper, more tape, scrambling. That's not even good enough. It's like that. It's like the state trying to find the right wrapping paper, but they don't make that kind anymore. And you're a child, you have no way to get it, and there's no more tape, and also you're trapped in a box and you're underwater. That's what this is like to me. But you're still trying. You're still trying because you really want to get that present. Like that's what this is right here. Like, in other words, I'm not expecting this to make any sense anymore. I'm expecting this to it's just nonsense. That's all it is. We're seeing the panic. It's like panic times a trillion. I agree. Yep. It's never right. It's never made any right. Yep. I don't know. I feel for you, Rochelle. That's terrible. 45 minutes from Delphi. Yeah. Okay. So I just have a visual in my mind of Santa in like a box underwater and like with like a thought bubble coming out of his head of like, and in the thought bubble is like this wrapping paper that he's trying to find for this present. And he's like, you know, yeah, it's funny. I just got a visual of that when I was describing that scenario. Anyway, defendant suggests unsealing the IG information will not affect jury selection because the issues raised here are legal issues. But defendant's witness disclosure for the hearing tells a different story, which that was sealed. So we'll learn who the witnesses are tomorrow, hopefully. A story in which the defense plans on calling multiple fact witnesses to discuss issues on right here, y'all. I would say if you were to go back and go through this case start to finish from day one, not that no one should, and go through every pleading and every filing and every hearing and every time they mention IGG and go through it and think about what I've been suggesting tonight, I would think that probably you'd be like, oh my God, this makes sense. fact witnesses on how IG was used in this case. Why do you think that is? This court can and should, consistent with Waller. Okay, blah, blah. That's the end of that document. Okay, so now we're going to go to the defense's reply. I mean, right? More like a fart bubble, and also accurate because of the underwater thing, right? Also, same thing with the PCA. If you go through that PCA and you go through it and you think about what I've just been explaining with the fake investigation to try to cover up how you actually got to the name and all that stuff, and the Chris is present analogy, again, it's like, why is this PCA trash? Again, if you go through it and you think it will make sense as to why it's all nonsense, right? Just like I said with Santa's, that paragraph I highlighted, same thing. Why is this nonsense? Why is it trash? Why is it word salad? You know? Okay. Okay, so comes now. Bloop, 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 bloop. Okay, Mr. Kohberger stipulated to a non-dissemination order to avoid over 100 law enforcement personnel from speaking publicly about the case before trial. That stipulation was in no way intended to circumvent his right to have matters properly before the court, heard openly in public, with a judge presiding over an adversarial hearing. The significant downside to having stipulated to the non-dissemination order is that Mr. Kohberger cannot correct the many false reports in the media, which have resulted in an overwhelming public sentiment of guilt. It is no surprise that the state wants no part in stopping that narrative and hence objects to an open suppression hearing where legitimate legal issues will be heard. Mr. Kohberger does not believe the non-dissemination order is the same as closing proceedings that are public. And that's exactly what the media was arguing. How interesting, right? So we saw Judge Hippler say basically exactly what the state said. Word salad and contradictions and made no sense. And then we had the media in that hearing, you know, they said the same thing that is here, right? Which is like the non-dissemination order did not apply she was right when she said that in the hearing, right? I remember that. I'm sure you guys do too. The non-dissemination order was for people coming out in the media or whatever and commenting, right? It wasn't applicable to the hearings or to sealing court filings, right? It is no surprise that the state wants no part in stopping that narrative and hence objects to an open suppression hearing. I already read that part. Sorry. Okay. The party seeking to close the suppression hearing over the objection of the accused must, this is important, advance an overriding interest that is likely to be prejudiced. The closure must be no broader than necessary to protect that interest. The trial court must consider reasonable alternatives to closing the hearing and it must make finding adequate to support the closure. The interests the state asserts are influence on the potential jury pool and possible inadmissible evidence. I just lost my place. Okay, being discussed in open court. This is odd because such matters are routinely discussed in court. Odd is one way to put it. And much of what may eventually turn out to be excludable as evidence in this matter was released to the public with no concern for Mr. Kohberger's rights by the state. Unsealing the pleadings and hearing post-jury trial does not present the court with a reasonable alternative to opening the suppression hearing. Absolutely. Yeah. Remember when I got pissed when I read that, when we went over the states and I was like, you gotta be kidding me? Yeah. That's why. This is why. Thank you for saying that. Defense explaining my thoughts here, that it's a straw man argument. It's a straw man argument. It's a logical fallacy. No surprise. It is no alternative since the recommended remedy is post-trial and his right to a public trial is now. Additionally, since all orders sealing matters in this case are temporary, offering to unseal post-trial is not an alternative. The state's concern about potential juror influence is misplaced. The only influence that there may be on potential jurors is their learning that there is more than the current guilt narrative about this case. It is no secret that a public hearing will allow the opportunity for the adversarial process to lend itself a fuller picture, one that is more than the current guilt narrative. Mr. Kohberger's Sixth Amendment right to a fair and public trial does not begin with jury selection. It begins the day he was arrested. Facts. Now, 2 years into the state having control of the narrative through its where'd it go? Through its extensive probable cause statement. I don't know. I wouldn't call it extensive. A suppression hearing is exactly the proceeding where his right to have motions heard publicly matters. Moreover, he holds the right to a presumptively open hearing, As to the state's point about the IGG being inadmissible evidence, Mr. Kohberger has the right to confront the evidence against him at trial, especially that which identifies him. There you go. Right? Previously, the state has, here we go with more. Oh my God. Previously, the state has characterized IGG information in this case as a quote. So these are all in scare quotes: lead, a tip, and informants. The state does not get to hide behind an informant to prove identity. Whether the state wants to describe the IGG identification as a lead, a tip, or an informant, such is testimonial in nature to prove identity. The purpose of the IGG was to investigate a criminal case. What's more, without IGG, this case would never have been brought against Mr. Kohberger. The Sixth Amendment's Confrontation Clause provides that, well, we all know. Okay, let's see here. We know what that says. Oh, here's some footnotes. Let's see. Okay, the genealogy conducted by the FBI. Remember, we talked about this on, again, the other live stream where we discussed this, but according to Gabriel Vargas, the FBI does not actually build, that's a whole other thing, right? Which we've discussed. The FBI does not build their own family trees. That's why they use third parties. The FBI does not do it. And my research on this has shown that it's currently now some FBI offices in, I think it's like 2 states in the country, have started programs within the FBI to train people to begin being able to do this. But that's very different than, so again, the whole notion that the FBI built the family tree, again, it's nonsense. It's nonsense. Again, why are they saying that? Remember, that's the whole Chris is present thing, right? They're saying that because they already had the name, because in my estimation, it was a direct match. Okay. And so in quotes, right, the genealogy conducted by the FBI resulted in a lead that pointed law enforcement to defendant. IGG information provided local law enforcement by the FBI was nothing more than a tip for local law to follow up on. And the state referred to innocent civilians identified in the IGG information as indirect informants. Okay. Conclusion. For the reasons addressed above, Mr. Kohberger respectfully requests this court grant his motion to unseal, These are Mr. Kohberger's rights and he asserts them. Next up. Oh, hi, welcome. Glad to see you again, American Princess. Awesome. Yeah, she was there via Zoom. I remember seeing her initials. Okay. Order regarding presentation of IGG evidence. Are you ready, guys? Now, I want to make a distinction here about Frank's, right? Remember, there's been, as I've said, there's a motion on the table for Frank's hearing. He has not ruled on that motion. I want to make sure, you guys, that nobody gets confused about argument on the motion for a Frank's hearing and Frank's hearing, because this is what's going to come up in this document, right? In other words, well, let's just read it and then I'll reiterate. Okay. As discussed with the parties at the January 21st, 2025 SAS conference, there's a significant evidentiary overlap between defendant's motion to suppress read genetic information and defendant's motion for a Frank's hearing insofar as it pertains to his proffer regarding law enforcement's use of IGG. Again, why do y'all think that is? Well, I already explained. All right, well, that's why I think it is. Anyway, although the hearing set for January 23rd is not intended as a Frank's hearing, in the interest of time and efficiency, the court will permit the parties to present their evidence on the IGG issues as if it were a Frank's hearing. By permitting such evidence, the court is not concluding or implying that the defendant has satisfied the preliminary showing required by Frank's on the IGG issue, nor is the court bound to consider the full extent of the evidence if it ultimately concludes defendant's proffer insufficient to warrant a Frank's hearing on this matter. So remember, that's why I was just saying that this is essentially him saying he still hasn't ruled, right, on if he's going to grant the Frank's hearing. The motion is still on the table, but they're going to go ahead, and since they're going to be there anyway, right, they're going to go through this IGG evidence that will also overlap with them making their argument in support of their motion for a Franks hearing. So in other words, what we can expect is that there will be a separate hearing at some point with the rest of the argument needed for the motion for a Franks hearing. Then we can expect Judge Hippler to rule on the Franks hearing. And then if it is granted later, then we can expect, I'm sure it'll be sealed, but we could expect at that point the actual Franks hearing. So we're ways away from it happening. Okay. Because again, even after tomorrow, or even after the 24th, there's still going to have to be another hearing for further argument on the motion for the Franks hearing. And then after that, a ruling. Okay. So this is simply intended as a time and resource saving measure. It is so ordered. Okay. Now, here it is. I cried when this came out, guys. I'm not even gonna lie. Not even gonna lie. I stopped what I was doing and I cried. Before the court is defendant's motion to unseal the IGG suppression briefing and hearing. A hearing on the motion was held on January 21st, during which the court denied the motion from the bench, which we didn't know until now. This order memorializes that ruling. As defendant has observed, this case has garnered intense, if not overwhelming, national and international attention in the media. This has led to the sealing of several files in this case pursuant to ICAR 32, which contemplates sealing information temporarily when necessary to preserve the right to a fair trial. Further, Judge then presiding entered a comprehensive non-dissemination order designed to prevent publicity about evidence that may or may not ultimately be admitted at trial from tainting a prospective jury pool. Among the sealed filings is the briefing on the defendant's motion to suppress genetic information, which the parties stipulated filing under seal. Defendant seeks to unseal this briefing as well as the hearing on the suppression motion. He points out that the public, so again, that would have been happening. Well, the motion is still going to be heard. It's just we won't be hearing it, but that, the upcoming motion, right? He points out that the public has long been aware that the law enforcement used IGG procedures in investigating this case. However, because the details of the IGG investigation have been withheld from the public, defendant contends there is significant and prejudicial misinformation circulating in the public eye about his guilt. Unsealing, he argues, will correct such misinformation, protect his Sixth Amendment right to a public trial, and preserve the public's First Amendment right to know what is going on in its courts. The state responds that it has no objection to unsealing the IGG evidence after trial, but doing so prior to trial poses a significant risk of tainting the jury pool. Again, like I said, he's just echoing Santa. Let's see if there's anything here on the footnotes. Okay. IGG was raised as an issue in this case in the defendant's third motion to compel discovery on June 22nd, 2023. The court previously handling this matter held a public hearing on the motion, which included testimony by 4 expert witnesses. How funny, right? We were literally just talking about this, right? We actually watched earlier tonight, we watched clips from Gabriel Vargas. I mean, funny, right? Here it is. Yep. The court ordered the protection of records in camera under seal. Yep. Defendant then saw additional IGG evidence through his fifth motion to compel. Over the defendant's objection, the court required the hearing on the motion to be closed and ordered the production of records under seal. And then it's just showing when those other hearings were. Okay. The First Amendment and Sixth Amendment guarantee the right to an open public trial. These rights benefit the accused to the extent the presence of interested spectators may keep his triers keenly alive to their sense of responsibility and the importance of their functions. It also ensures that judge and prosecutor carry out their duties responsibly and encourages witnesses to come forward and discourages perjury. This right extends to pretrial suppression hearings as well. Nevertheless, the right to a public trial may yield to an overriding interest based on findings that closure is essential to preserve higher values and is narrowly tailored to serve that interest.
And this, I'm not going to read this again. This is exactly what we already know this. We heard this in the hearing, and this was also stated in the other previous filings. As the state pointed out or points out, this is stupid. As the state points out, the defense also says this. But see, this is, damn it, you guys, damn it. I mean, this is where it's getting to the point where it's like, fuck, is he that prosecution leaning, right? Because, I mean, hello, why do you think the defense, Judge Hippler, why are you on this case? Oh, I know why. Because the defense made a motion to change venue and demonstrated before the previous judge, the previous court, demonstrated the nature of this high-profile case. That's the reason you're here, Judge Hippler, because of the defense. So the reason I'm mad is because there's no need to be like, as the state points out. It's not necessary. He could have said either. He could have left this out completely, and he could have just said, there's no dispute that this is a high-profile case, because that's factually true. No one's going to dispute that. Or he could have said, as the state and the defense have pointed out, there's no dispute that this is a high-profile case. The reason I'm mad is because instead, words matter, right? He chooses to say, as the state points out. This just shows, this to me just is like, not like I say he chooses. Let me rephrase that. This to me is subconscious bias. That's my opinion, though. I can't say it for sure. That's my opinion, because there's no need for that. Another example of that, Judge Bev did the same thing in her recent, when she granted the testimony of Dr. Russell. There was a lot in that order that was not necessary, but it just showed her bias, and there was no need for it. This is a similar thing, in my opinion. Fuck. And here's what I'll say. I know a lot of people have their own opinions about Judge. Y'all know me. I've said it a million times. I loved Judge. And I will also say this much. I did not get the sense that he was heavily leaning or biased, if you will, in a way that would have an actually direct impact on things, right? Like, I felt like he was fair. I mean, I know he took in most people's minds took too long or whatever, but he was very fair and balanced in my mind and didn't show. I mean, this is glaringly obvious here to me, but that's just my opinion. Okay, let me keep reading. It was transferred to Ada. Oh, yes. Y'all, literally, Judge Hippler now is saying what I just said. This is so dumb. This is so dumb. It was transferred to Ada County from Latah County on defendant's motion to change venue. Defendant argued in that motion that the small size of the jury veneer and the extensive inflammatory media coverage prevented him from receiving a fair trial in Latah County. While Ada County has a larger jury pool to pull from than from Latah County, the state is concerned that the risk of exposing that jury pool to evidence, particularly evidence that may not be deep. Okay. Let me take a sip of water. Here's what I see. Here's my take on this, guys. There's a lot of that thing happening where you're arguing one thing for a different reason and you're not saying the real reason. And like, confusing the issue, if you will, or like, also there's like the more straw man business happening as well here. What do I mean? What I mean is that everything that is being said here is based on an intentional mischaracterization of what the defense's positions have been and still are, in order to then make it look like the defense is being two-faced or wishy-washy, however you want to say it. Here's what I think is going on. The state and Judge Hippler also now clearly, I think they are wanting it to look like this to the public and the media. If I'm them and I'm trying to quote what I think they're thinking, they want it to be like this.
They want to hear people come out on the media and say something like this. The defense in Bryan Kohberger's case, you know, initially they were complaining that there was, you know, too much coverage and, you know, blah, blah. And now they're doing a 180. And now they want people to know, now they want exposure. It's so irrational. I can't even do a good example. I tried to do an example. I can't even do it because it's so irrational. I can't even think of an example to do it. I tried. Maybe you guys know what I meant though, hopefully. But all of that is inaccurate and is irrelevant and is confusing the issue and taking it away from the actual issues. That's so here's what I'm saying. Y'all, when you guys see people commenting, or whether it's mainstream media or social media, and you see people saying something to the extent of what I was just trying to do in my example, which is look at Bryan Kohberger's defense team. Like first they want the jury, they want a different change of venue, and now they want people to know things. Keep in mind what I just said, that's them buying, or that's this working. This is like a propaganda, like I can't even, like this is like wanting people to think that. It's like gaslighting or brainwashing. It's like they want people to think that. And then that will be the narrative. That's what's happening here. So every time you see that and hear that, that has succeeded. But I want you guys to know that my interpretation of all this is that is being done on purpose. And it's literally, again, it's gaslighting. It's trying to make a presumption based on a intentionally false interpretation of the defense's position. So everything that is in this here is based on a misconstruing of that. So therefore, all of this is false and irrelevant. Is that making sense, guys? And the other thing is this, and they know this. This is again, they had to make a motion for a change of venue. They do that in so many cases that are like not even that high profile. Like it happens it's like, honestly, if they didn't do it, it would have been an issue for ineffective assistance of counsel, right? They had to do it. And the thing is this, because they did it, right? Ada County has a larger jury pool. So in my mind, it went without saying that this is what the situation was. There's no, in every trial, guys, they find a jury. In every trial, right? This is not the highest profile trial of all time. I would say Casey Anthony, this doesn't even come close to that in terms of the publicity and the media and all that, right? In every high profile trial, they always seat a jury, right? So my understanding, and I thought everybody was on the same page, and by everybody, I mean the parties in this case, but was under the assumption that because they went to this larger county, that just like in every other case, they're going to be able to find a jury where enough jurors either haven't really heard of it or they've heard of it, but they haven't heard enough to form an opinion, and they seat a jury. Therefore, with that being accepted, that's why we changed to Ada County. It's like, because we changed to Ada County, check. And that's what Judge Hippler even said in the hearing when I pointed out the contradiction. It was like, check, we're all set there. We're good. We're good. We'll handle that when we get to voir dire, but we're good, right? So now, because that problem is solved, now the thing that matters is the information to the public. Like now it's like you want the public to have the correct information because you don't have to worry about the jury pool. Does that make sense? That's why you changed. Had they still been in Latah County, maybe it'd be different, but like they wanted to move to Ada County. I'm sure they wanted that done, right? The change of venue was done before the suppression hearings, right? Because obviously for the reason I just outlined, right? They want to feel like, okay, check. We don't have to worry about the jury anymore at this juncture. We've got to Ada County. Now we want to be able to get information out to the public. Anyway. While Ada County has a larger jury pool to pull from than Ada County, the state is concerned that oh my God. The hypocrisy. You guys know how I feel about that. While Ada County has, I'm going to have to just read this and not think about it because while Ada County has a larger jury pool to pull from than Ada County, the state is concerned that the risk of exposing that jury pool to evidence, particularly evidence that may not be deemed admissible at trial, remains significant. The state is concerned. So you guys, this is making me nauseous. I'm not even kidding. This is making me nauseous. The state objected to the change of venue. They weren't concerned about the jury pool. They fought that tooth and nail. Prosecutor Santa got all mad and spicy. Where is he? Santa. There he is. They weren't concerned about it in Latah County. However, now that they're in Ada County, they're concerned. Why? Again, Plan J, like I said earlier. Plan J, grasping at straws. And this is Judge Hippler backing them up. What this is saying to me is Judge Hippler, again, going back to the Chris is present idea, Judge Hippler must know that they're fucked. And this is not his job. His job is not to save their asses from this case getting completely thrown out. But that's what I think he's doing. That's what he's doing. And that also would explain why he's echoing exactly what the state is saying, because none of it makes any sense. He's protecting them, I think. I think he's protecting them. They have to do everything. And by they, now I'm including Judge Hippler. It shouldn't be this way, obviously, but they have the government, okay? The government, they have to do everything to keep this IGG from coming out and from being dealt with. Again, IGG, not IGG. Because otherwise, they're fucked. And why is Judge Hippler helping them? I mean, it could just be he's that biased, or it could just be something to the effect of like, again, you think it's the right guy because you got the name, if you know, again, through the DNA database, you know, direct match, whatever. The ends justifying the means type thing, right? Like we talked about this last night, I believe, right? The ends justifying the means. We're like, just like when we heard from Gabriel Vargas talking about the reason they do the backdoor things in the first place with the IgG, right? Or the, you know, the databases, right? The reason they do it is because it was initially solving like DOE cases, right? So they felt justified because they felt righteous about it, like because it's a DOE case, and you know, and so they determined it was okay to break the rules, right? The ends justifying the means. And in this case, if they're like, well, we think we have the right guy because it was a direct match or whatever, again, the Chris is present example, the ends justifying the means. And so again, either Judge Hippler is just really biased, or it could just be something like knowing that this would all just be thrown out and like the amount of money that's been spent on it, for example. I'm sure there's other reasons too, but that's just, you know, it's just, he's protecting the state, I think, here. The court agrees. The other thing I will say is this too. Initially, when he first got on the case and he hadn't had any of the discovery yet, right? Like, I'm seeing a change over time. Are you guys seeing a change over time? Let me ask you guys this question. Are you guys noticing a change over time in the rulings from Judge Hippler? Are you guys noticing a change over time? I am. Personally, I am. And the change that I'm seeing is it's like, it seems to start out kind of balanced and whatever, and just like going by to where now it's not that way anymore to me. And again, why would that be? Because he's been getting the discovery. He has seen the evidence, contrary to what he said in the freaking hearing, right? He's seen the evidence, and now he knows. And now he knows, and now he's protecting the state. That's what I think is going on. Just my opinion. Okay, the court agrees. The United States Supreme Court has recognized that publicity concerning pretrial suppression hearings poses special risks of unfairness because it could inform potential jurors of inculpatory information wholly admissible at trial. Given the intense media scrutiny generated by this case, particularly in Idaho, the potential that the IGG evidence will not be admitted at trial. The state just said in their document, though, that they think it might come in at trial, which I remember when I freaked out because I was like, what the fuck? Remember that part? You guys, look, let's do a side by side. This is making me really sad. Oh my God. 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 Okay. So look, guys, I'm going to lose my mind. Look, this is from what we just covered. This is the state's some bullshit. Doesn't even matter. Look what they said. Here. There are still questions about the extent to which the IGG information may be presented at trial. Okay, back to where we were. This is from Judge Hippler. The potential that the IGG evidence will not be admitted at trial. So what's happening is part of this is so fucking fucked up. They're arguing the complete opposite things depending on what. Okay, so here, guys, this is depressing. Here, because this is about arguing that you don't want to have it unsealed, right? The state's saying, well, it may be presented at trial, right? So because we don't want to poison the jury pool, and this might be presented at trial. So don't unseal it because it could poison the jury pool, right? And now here, Judge Hippler is saying that it should be sealed, right? Denying the motion. It should remain under seal because it will not be admitted at trial. Help. Yes. It is that's an understatement. I just yeah. And see, the thing that I'm thinking is like the question I was asking about as it pertains to the change in Judge Hippler is like, and like why? And like my thought is the why is because he's seen what's going on. He's seen this is not normal. None of this is normal. Remember, we even heard Vinnie Politan. I started this live stream with those clips from Vinnie Politan. None of this is normal. This is not normal. Vinnie said it as well, right? Every high profile case he's covered for decades. I mean, we know this anyway. I'm just reiterating. This is not normal. And every case, there's always issue. like, what is different about this case? That's what he literally said. What is different about this case? Because other cases are high profile. Other cases have DNA. Other cases have IgG. Other cases have other issues. Other cases have all the things that people think are the real issue in this case. Other cases have those. So what makes it different? In my opinion, again, the real issue is the thing that nobody's picked up on yet, which is again, potentially everything that I have looked at is pointing to one solution to that, which is that direct match, and that he had opted out. And that happened so quickly, and it was the first thing that happened before they submitted it to CODIS. And again, Chris is present. This is the first time. And actually, I did read that in an article as well on that live stream I keep referencing. We read that. It's never happened before. It's never happened before. It's never happened before that a criminal defendant has been a direct match to themselves. And remember, we knew from the get-go. We heard this. This is a case of first impression. There's no precedent. We heard Judge say this. There's no precedent. We heard Judge Hippler say the same thing. There's no precedent for this. Why? This has never happened. And I've been saying it was a matter of time before somebody commits, whether they did a crime or not, right? It was a matter of time before DNA would be found at a crime scene, right? And that would be a direct match to a person. It was a matter of time. And had not happened yet, in my opinion, until now. I think it's happened here. And that's why this is different. Now, here's the other thing. Had that happened after they had already gotten the name by other means, like an actual investigation, let's just say, for the sake of the example, that they did get a direct match. Even let's just say they still backdoored all that stuff, right? But let's just say that happened in just, months down the road after the homicides. Let's just say that happened after they got to him another way. I don't even care what other way. Let's just say that they already had his name. They were already investigating, right? And let's just say that they were like, well, let's just for fun, just for funsies, let's go ahead. Let's just chuck this into let's just go ahead and put an S&P and and see. And then they get a direct match, right? Completely different situation because if they've already built a case and they've already got other things, right? But this was the first fucking thing they did. They would have been less fucked had they just waited to send it to Othram. And the other thing that's odd is that usually that was already unusual. And I've mentioned this before. That was already unusual because usually IGG is a last resort. So it was already unusual to me that they sent it to Othram before putting it into CODIS because first of all, that doesn't make sense. It's unusual, but also that breaks the rules, which we already covered. Step 1 is supposed to be CODIS. But it is unusual anyway, because usually IGG is a last resort. IGG is a last resort. But it was the first resort that they did. Think about that, guys. It is meant to be used as a last resort when you haven't run out of options and you're shit out of luck. And it was the first thing they did. And that's why they're extra fucked, man. Had they just waited, they could have been less. I think they still would have been, it could have been an issue, but they would have been less fucked than they are, I think. Okay. But yeah, this is just insane. The court is concerned that releasing the IG evidence by making the briefing and testimony portion of the suppression hearing public poses too great a risk in tainting an already relatively limited jury pool. What? Again, I don't even relatively, hold on. Ada County has a larger jury pool to pull from than Latah County. An already relatively limited jury pool. I mean, are you saying that that you need to change venue again? I don't understand. Again, this is arguing both sides, arguing. It's just contradictions. So now it's too small? Well, then don't we need to change venue to somewhere else then? Anyway, such protection ensures inures, I don't know what the fuck that word is supposed to be, to the benefit of the state and defendant equally. Further, having considered alternatives, bullshit, the court finds that keeping the IGG briefing and testimony temporarily sealed after trial at the latest is no broader than necessary to protect the integrity of the trial and the jury pool. What are you really protecting? This isn't it. This is not it. We have just gone through how that's not it. The jury pool, that's nonsense. The integrity of the trial. You're saying that there's integrity of the trial by keeping things sealed? You've got to be fucking kidding me. What are you know what this is? Chris is present. He's protecting the fact that they cheated and opened all the presents and they can't find the right wrapping paper and the tape and all that, like I've already said. That's what this is. It is the only way to allow the court to examine the admissibility of the IG evidence without exposing that evidence to the public and to protecting potential jurors and in turn, the right to a fair trial. The parties' legal arguments on the IG evidence will remain public. This approach, well, thank God for that. This approach, blah, blah. So we'll get to at least hear that part. This is oh my God, look at this nonsense. Taint. To guard against the taint of pretrial publicity, courts consider alternatives such as changing venue and questioning potential jurors during voir dire. However, changing venue yet again, like it's funny because I just said, Judge Hippler, are you suggesting they should change venue yet again? However, changing venue yet again would not result in a less biased jury pool. What? Then why did you even make the distinction that Ada County was relatively small? Anyway, further courts recognize that in cases saturated by media attention, voir dire cannot sufficiently remove the taint of pretrial evidence. This is just nonsense. This is just, yeah. I'm just glad I'm not his defense attorneys. I would be losing them. I am losing my mind. I'm just glad I'm also not losing my mind and also his defense attorneys because I can't imagine what it must be like for them. So real quick, I'm going to go back and try to find the part about the initials here. I'm just going to see where this is at.
One is that it's possible, of course, to show exhibits on a monitor.
Okay, so it's after this.
That order was challenged, I believe, by the press at the time, and the full hearing was held on that, and the judge issued an order on that. The closure of the proceedings thus far have been consistent with that prior ruling by the court, for which the petitioning parties were given an opportunity to be heard previously. I don't think much has changed in terms of the need to protect the jury pool here, given the intense media scrutiny.
I mean, we've already covered that part. I need to go forward a little bit. I'll just get ranting again about that, but I'm just going to get to the initial thing.
As I told the parties yesterday, particularly sensitive about closing things when we don't need to. And I think that there has been to date a over caution in asking that I seal things by stipulation that perhaps don't need to be sealed. And I've asked the parties to stop that, frankly, and
Stop that.
provide
You.
better rationales as to why.
Yeah, that's the only thing that I appreciate of what he has said today. That I appreciate that. That's good. That's all I can say. That's good, though.
The potential impact on a jury pool. In this case was moved to this court because of the defense's assertion that they could not get a jury pool in northern Idaho that would be
literally what I was saying. So we watched this before we read literally what I was saying, right? Again, the narrative. He is doing this. He's doing the state is solid. Here's the narrative, and then you guys will hear people repeat this narrative, and it's just remember it's completely based on a false premise. So
unaffected by the case, even with the non-dissemination order in place. The media here in Ada County is as, if not more.
You thought that was funny too, the way he said "stop that" with. Kind of want to hear it again. It was really fucking funny. Let's hear that again.
Unaffected by the case, even with the IGG issues, in asking that I seal things by stipulation.
Here we go.
That perhaps don't need to be sealed, and I've asked the parties to stop that, frankly, and to
stop that. You just fucking funny. Okay.
with the non-dissemination order in place. The media here in Ada County is as, if not more, intense. And so I think there is need to.
So also, yeah, they do mean literally taint the jury. Yeah. What is the meeting that people had? I'm just trying to catch up on things. Okay. So
to be careful when we are addressing evidence that potentially is not going to be evidence in the case because of suppression motions, motions in limine, and the like, which is the concern.
let me go forward a little bit.
Will not open the courtroom itself to parties in the courtroom because of the need to close it if I find or the parties suggest to me, and I agree there's a need to discuss something at that moment outside the public's reach, which is easy to do by simply going offline for a minute. And that's what I intend to do tomorrow. In particular, the evidence with respect to the IGG, I think at this point it's appropriate to, and I will issue an order shortly, to keep that out of the public domain for the time being. Now, that may change down the line. My order certainly on the issue will ultimately give some information so that people can follow what happened from a legal perspective. But some of the
Yeah, there was no
factual
legal
details, until I know what those are, and I've seen that, I can't make that determination better. And so I think that this is the best way to proceed because I can't unring a bell once it is rung with respect to potential evidence that in particular may not be evidence in this case. And so my intent would be to proceed with the evidence portion of the Franks hearing as it relates to IGG in a closed environment. I think we can decide at that time before we go online whether we can have the IGG portion of the Franks proffer publicly. The intent is, I think we understood from discussion yesterday that the rest of the evidence and the arguments, both on Franks and suppression as it relates to everything else, we should be able to do public. If there's an issue that is specific,
Okay.
like Ms. Massoth brought up, the need to mention a name that we need to protect from.
Okay, hold on. Let me back it up a second. So I wanted to go back and I thank you to you, Twizzle Stick, for mentioning this because that gave me the idea. Hold on.
The arguments, both on Franks and suppression as it relates to everything else, we should.
Here, everything else, y'all, there it is. Remember, so because that's why I wanted to go back because I was like, I will be surprised if there's a list of names as it pertains to the IGG. Listen. The initials, remember, and it's still weird that he swapped initials, the numbers for initials, but whatever. But this, he's not talking about IGG. There is no list of names. There is no list of names. Okay. Listen, it's to everything else, the other motions to suppress. Listen.
And the arguments, both on Franks and suppression as it relates to everything else.
Everything else besides IGG.
We should be able to do public. If there's an issue that is specific, like Ms. Massoth brought up, about the need to mention a name
There.
that we need to protect from.
Everything else. So in other words, not IGG, not family tree, not IGG, guys. There it is. Now, I understand how hearing this, and because the names are a big factor that the state has perpetuated or initially did, it kind of gave up on that one. Initially, the state was peddling that. Again, that was their plan A, right? Like I said, plan A. But then again, we know, and Taylor said, there's no names mentioned in the briefings, right? But anyway, should anyone have heard him say names and have thought, oh, that's probably pertaining to IGG, totally understandable why one would think that. But I just wanted to point out, so we can know for a fact, literally he's saying everything else. So these names would be, I don't know, law enforcement officers, roommates, I don't know. Y'all probably have some ideas. Whoever might come up, right? In the as they talk about, you know, I would say law enforcement officers are probably an option there, or you know, maybe people who made phone, you know, if they're going through the cell phone, right? The motion to suppress, maybe there's like people made phone. I don't know. It's the point being, using the initials is not IGG names. It's names from other things, not IGG.
Unwarranted harassment, which has been a concern in this case, we can certainly refer
I
to
mean,
them by
also,
initial, particularly if you give me a roster with
right?
initials or other identifiers you'll be
I know.
using, then I can follow along. And I think that's the better way to proceed so that we can do as much of this in open light as possible. So I appreciate the petition. I don't think it has changed. I appreciate the defense has
There it is.
shifted its.
There it is. So at this juncture, everything that we talked about tonight, and I've talked about on the other live streams too, that the potentiality that there's only one name because it was a direct match, that still stands. That still stands. So just keep that in your minds as we go forward with this case, regardless of wherever you're watching it, whether you're watching a hearing or, doc, whatever, right? Or just thinking about, keep it in mind and see if it fits with like things that aren't adding up and don't make sense. Because to me, I think that, and again, if you want to see the full layout of how I got there and why how I arrived at that I'll put that live stream in this video's description where I go through that in like step by step. Oh, what else was I just going to say? I interrupted myself with my own brain. Squirrel brain problems. Oh, fuck. Well, so yes. But keep that in, right. We keep that in mind as you hear things. So, man, a funny thing, right? So for tomorrow, for the hearing, I was coming up with like the thumbnail and I realized like there's so many 3-letter like abbreviations in this case. So like there's like IGG. I didn't even use the word DNA. There's that too. There's a PCA, FBI, MPD. And then I've recently started using this theme of like, because I think this is where we're getting to here is war, also 3 letters, right? That there's going to be a war over this IgG and it's going to be a bloodbath. That's what I think, because remember, they are going to do everything possible to keep this under wraps, keeping it wrapped up like a present because they're fucked otherwise. That is what I think. And, but my plan is to go and probably watch that after the fact, just because I know there's going to be a lot of people streaming it. And that way it'll, I know most people want to watch it more than once anyway. So everyone will have a chance to sort of hear it. And then, and I'm going to be watching it, of course, live, but streaming it later. And I'll do the same thing for Friday. The other thing I'll say is this, for any of you guys remember like during Delphi, when we were waiting on the verdict, and I don't know if a lot of you guys are new, but I'm sure you probably experienced this, but didn't know that I was experiencing it. So anyway, when waiting for the verdict, right? Did you guys have that thing where like literally you were under so much anxiety you couldn't even proceed with daily life? Like to function, like you couldn't function. Like that was me waiting on that verdict. I could not function. It was awful. Like literally, it was all I could do was like, I don't think I slept, even though it's like, there's not going to be a verdict overnight. It was just awful. And so I had at least one or if not more live streams that were like literally called like, Delphi, like anxiety support live stream or verdict watch support live stream, something like that, like emotional support live stream, right? Because it's like because I knew there were other people that were feeling that same way. And there were, and that are just like, I can't handle it. Like I need somewhere to go where I can like have support. You know what I mean? Anyway, so for anybody who's feeling like that about this and in this moment, I am as well. I am as well feeling like that again here. And maybe not quite to the same extent, but pretty close. Of like the anxiety and like what the fuck's going to happen and when is it going to happen? And it's just, there's a lot of unknowns, right? And that's what made it so hard too. Well, every verdict is hard for that reason too, but it's sort of like, and you don't want, it's like, when did something happen? Like trying to check and, that's as it pertains to Delphi. But anyway, so for anyone who is like thinking, like feeling that way, right? all that to say, I may end up going live again here shortly, because I don't know. I'm gonna this is upsetting. What's happening here is upsetting to me, and so I'm gonna try to do other things, but I may not make it. So here's what I'm saying. I may come back with another live stream, and what we would do is something completely different so that we don't have to think about this momentarily. Like, in other words, what I would do is I would probably do, I've set up a live stream for the Adelsons doing, going over those PCAs, and, you know, for the PCA for Katie McBenoit and the PCA for Charlie. And if you're like, what the fuck case is that? Don't worry, because the PCAs will go through the entire case. And that's part of the point. And then also watching some testimony from Charlie's ex-girlfriends. And so it might just be a good distraction. So we'll see. Thank you. So yes, Stradivarius. So for anyone who missed it yesterday, I was talking about my violin was made in 1757, which is 7 years after Bach died, and older, makes my violin older than our country. So there's that. So yeah, but other than that, yeah, I'll be covering the hearings. And for anyone who missed it at the beginning of the live stream, we do have a Squirrel friend who is boots on the ground in Boise and is in the Discord, and is going to keep us updated with what's happening. So for anyone who wants, I know there's going to be other boots on the ground, right? But anyway, I just want to throw that out there because, and also, as always, if you haven't joined the Discord, join the Discord. It's awesome. I'll put the link in the chat as well for that. So yeah. Oh, that's funny. I didn't even see that till now. Yeah, there's the Discord. So speaking of it, and I've had a couple times people say the link doesn't work, but I know it worked just tonight already for our Squirrel friend who's a boot on the ground. But for anyone, if the link doesn't ever work, you can just do a search for Law Squirrel. Apparently there's 2 channels that pop up. I'm shocked that anyone else has that. Look for the Squangwin. And, you know, if there's more than one, that's the right one. Obviously, look for the Squangwin, as always there. But yeah, hopefully the link will work. And also, let me put a link. And the thing that's fun too about Discord is you can use all the commands. And so here's also the commands, because we love Nightbot here. So, and the other thing too, Discord, that's about too, it'll always give you notifications when I'm going live. And because as you guys know, the YouTube notifications don't always go through, but Discord is very reliable. I've never had anyone say they didn't get a notification through Discord. So like, for example, like if there's like a random anxiety live stream that happens in like an hour or 2, you'll get, you know, if you're interested, you'll be able to find out about that as well that way. And I'm seeing people are joining the Discord. Yay! Awesome. Squirrel crew. Yay. Yay, yay. Love it. Love it. Love it. I'm saying hi to you guys. Awesome. So, but that's it for this moment. But yeah, hopefully you guys felt like this was beneficial in some way. Maybe it helped you kind of see some other things, you know, or have maybe another understanding about what should have been going on with the IGG and what is unusual about this case. You know, I know that you guys also enjoy getting to chat with each other, but yeah, I love getting to see you guys, and old Squirrel friends and new. Welcome to the new Squirrel friends, and I appreciate y'all being here and for being awesome. But yeah, that's it for now. So other than that, unless there's, you know, we'll either be back tomorrow with the hearing, or like I said, potentially maybe in a support live stream here shortly. We'll see. So, but that's all for now. So love you guys and see you guys next time.